Samagra Shiksha Abhiyan, it is the seal is not much clear, but it is signed on 8/3/2024. Then on page 25 also,
Is it district project coordinator?
yes, Office of the District Project Coordinator, yes. And on page,
Supply was made on 20th of February,
yes, 20th of February.
24.
Then another one is on 27 March 2024,
Where is that?
page 25.
25.
Two delivery challan is there.
There are two dates, 20 February and 27 March.
Yes.
Then legal notice to file suit. Why didn't you file suit? Now tell me one thing, going back to the supply order,
Yes.
it says that as per the resolution of the district level purchase committee, Samagra Shiksha, district level purchase committee, they are authorized to place such an order. What is the process?
The process, I don't know what the petitioner was
See-
simply selected, yes.
Anticipating the response from the respondents.
Yes.
In anticipation, they might say that it was not authorized. They did not have the power to place an order like that.
Yes.
Something, they might say that also. That's why I'm asking you.
Yes. Yes.
What is the process? It appears that a resolution was taken
Yes.
by the district level purchase committee.
Yes.
You have the district level, you have the state purchase committee is also, what do you call that? There's a board, I think.
Yes.
You are not aware about the resolution?
Yes. The resolution is not available with me.
Yes, who's appearing for the state? Who are the parties?
Uh,
Special secretary.
yes.
We don't have a secretary. School Education Department. Ms. Lalunhui.
Your Lordship, there is a commissioner secretary.
Why do you make special secretary a party?
At that time, there is a special secretary that the legal notice was also received by the PS to Special Secretary School Education Department on page 30, 24/4/25.
That was in April 2025.
Yes.
Where was it received? Okay, special secretary. All right, anyway, you just take instructions. Hart Mr. Lalpian Fela Chongtu, learned counsel for the petitioner, who submits that the petitioner is a registered firm and engaged in the supplying of sports goods. Stop. He submits that by 4 separate office orders a supply order was placed to the petitioner for supplying sports materials by giving the details. Stop. The 4 supply orders were meant for supplying sports materials to the senior secondary schools, comma. No, before that you write government senior secondary schools, comma, government secondary schools, government middle schools, and government primary schools in the district of Kolasip. Pursuant to the resolution made by the district level purchase committee, Samagra Shiksha, Kolasip district, which held its meeting on 19/10/2023. The Learned Counsel submits that in terms of the supply order, the sports goods as was required to be supplied have been duly delivered white delivery challans dated 20/3/2024 and 27/3/2024. Bracket Annexure 6 to Annexure 6 to 10, 6 to 11. So the Learned Counsel submits that even after the delivery of the goods, since payment was not made to the petitioner, a legal notice was served upon the respondents on 23/4/2025. But as there is no response, the petitioner, having no other option, has filed the instant writ petition. So the Learned Counsel submits that the total amount of the total value of the sports goods that has been supplied is rupees 1794,400. Next para. In view of above, issue notice of motion returnable by 3 weeks. Ms. Lalnun Louis, Learned Government Advocate, accepts notice on behalf of
Respondent number 1 to 5, Your Lordship.
even 4 or 5 also.
Your Lordship, on no, Your
Samagra
Lordship,
Shiksha.
I will have to seek instructions as to whether we can represent the.
Respondent numbers 1 to 3.
Yes, Your Lordship.
Extra copies of the writ petition be furnished to her, if not already done. Stop petitioner to take steps for service of notice upon respondent number 4 and 5 by speed post within 3 days. List again after 3 weeks. Stop pendency of the writ petition shall not be a bar for the respondents to mitigate the grievance of the petition.
Oblige, Your Lordship.
For orders, item 8.
Yes.
Your Lordship,
What is this? This is an application.
application
IA.
for condemnation of delay,
Delay for filing RFA.
RFA, yes.
You are the applicant and appellant.
Yes,
How many days delay?
304 days,
204.
304.
304. Who are the respondents?
Respondent number 1 is represented here.
My Lord, I'm appearing for the respondent number 1.
Number 2 and 3 are not here today.
1, you're for 1. Who about 2 and 3? Has notice been served?
Yes, my Lord. Respondent number 2 and 3 have no objection with regards to the IS.
How do you know? How do you say that? You are for the applicant.
They have submitted no objection.
Where?
They don't submit any objection, Your Lordship.
They did not submit any objection, but anyone has appeared for them on behalf? 3. Any objection to the... And what about 2? You don't represent 2 also? Or legal aid. And who's number 2 then?
My Lord, the respondent number 2 was represented by Mr. P. Silal Thangmoya.
Where is he?
Seems he's not here today, my lord.
Yeah, what all things have been filed here? Just tell me. You have filed written objection by respondent number 1. First of all, this is the (304) days delay. This is the application. Respondent number 1 has filed objection. Then you have filed additional affidavit also.
Yes, my lord.
Why?
To incorporate the date of filing the review petition for the trial court.
Your additional affidavit and written objection by respondent number 1 have been filed on the same day. And what is this? This is written objection by respondent number 1. How many written objection have you filed? 2.
My lord.
1 is not enough.
My lord, since there were, my lord, the one objection is for the condemnation of delay, and the other written objection is filed in the another IA, which is a leave to file an appeal.
So which one is which? I don't know.
IA 177 of 2024 is for condemnation of delay.
177
Yes.
and 178.
And 178 is for leave to file an appeal. My lord, this
Okay.
is a third-party appeal filed by the instant
All
applicant.
right. Where's the third party file? I believe. You should keep in the appropriate file. Well, mixed up. Everything is mixed up. Registry also is not doing things. You should put the affidavits, objection, the bottom. It should start with the application or the writ petition or whatever. And whatever is filed, it should come down. It should go in serial, no? Because otherwise whatever latest has been filed is on top. And we have to dig out the original application. Then this Dasti service. This is Dasti service affidavit.
Yes, my lord.
Upon who, which respondent?
Respondent number 3.
3.
Yes, my lord.
Mr. Roku is for number 2. You are for 3. What is the name? Number 3? Yeah, Vanda Siati. The signature is here. Then Celia Kumi is number 2. Correct.
Yes, my lord.
And he's represented by he's represented by
Mr. P.C. Latangmoya.
where is he? Did he appear at any point of time?
Yes, my lord. He had
What
he
is
had
to be
entered
done?
appearance.
Do we go ahead without him or what is to be done? When did he appear? P.C. Lalthamoy is also legal aid counsel.
No, my lord, respondent number 2. I'm appearing on behalf of Mr. Tamoya Nasir.
Yes.
He is indisposed and he isn't able to attend this honorable court.
Okay.
And we have no objection regarding this incident IA, my lord.
You have no objection.
Yes, my
Good.
lord.
Now only Mr. T. Zekima has objection.
My lord.
All right. So we proceed. You are Mr. Lalbiak Chwama.
Not be from my lord.
Okay. So tell us, what was the order passed? When was the order passed? What kind of order was passed?
To 26/9/2023. In civil suit number 40 of 2023.
Order date is 25/9.
25/9. Your Lordship, the applicant purchased one RCC building on December 12, 2022.
No, no, don't go on the merits. We are on the delay. Order was passed on 25/9/2023.
Yes, my lord.
And when did you file the appeal?
Review petition. Appeal was filed on 22nd October 2024.
22nd October.
My lord.
The seal of the court is, registry is 23rd.
Your Lordship, a verification and affidavit was registered on 22nd.
No, verification affidavit on that day, but it was received by the court on 23rd October.
Lord.
Correct?
Yes, my lord.
So date of order is 25/9/2023.
Yes.
Filing of the appeal is on 23rd of October 2024. And in between there are 304 days delay.
Yes, my lord.
What is the limitation for filing an appeal?
90 days.
RFA. So minus 90 days, there is 304 days delay.
Yes, my lord.
Correct? Now, has the office computed the number of days delay? It's recalculated and found to be correct. Okay. So now tell us, what is the reason for the delay?
Your Lordship, the applicant purchased the residential building on December 12, 2022, which is covered under LSC number 1025/12/01/514 of 2005, which he purchased from the opposite party number 2. However, without the knowledge of the applicant, the building purchased and occupied by the applicant, it seems to be ordered and decreed in favor of the opposite party number 1 by the Civil Judge Senior Division 3 Aizol in its order and decree dated 25/9/2023 in Civil Suit number 40 of 2023. The applicant gained knowledge about the institution of court case and the final order passed by the trial court on 4/4/2024. In this connection, it is submitted that in the last part of March 2024, some person seemed to be the lawyer engaged by the opposite party number 1 approached the applicant in his house by telling that he and his family might need to be ready for moving out from their house from the second week of April if the opposite party number 2 still fails to make repayment of money on 4th April, and they feel that the Honorable Court may pass order for locking the 2 RCC buildings, including their residence. Hence, the applicant, where some disputes exist where his building was involved, he therefore consults a lawyer who advised him to follow the opposite party number 2 secretly to the court for gaining knowledge about the actual condition of disputes. Accordingly, on date 4/4/2024, the applicant, by following the opposite party number 2 up to the court premises in District Courts Aizol,
Just a minute. You have purchased the building, the property from whom? Respondent number?
2.
Respondent number 2.
Yes, my lord. Respondent number 3 is the registered owner,
Okay.
but this
Respondent number 2 is represented by Mr. PC Samboya. Okay. And 3 is by Mr. Rokuma. Correct. And who is number 1? What is the role?
My lord,
What is your role?
my lord, my role is that I have been declared owner.
By the trial court?
Yes, my lord.
Okay.
Because
You are related to, okay, no. There's some money was
yes, money was borrowed from me,
borrowed from you.
and yes, and
So trial court has declared you to be the owner
yes,
as in this civil suit 40 of 2023.
My lord.
Okay.
and that order was passed based on a compromise decrement.
Between?
Compromise deed between the
You and?
respondents hearing, the respondent number 1 and the respondent number 2.
1 and 3.
Yes,
1
my
and
lord.
2.
One and two, my lord.
1 and 2. 1 is yourself.
One,
2 is the original owner. No, 2 is the,
One
registered
between the
owner.
respondent number one, number two said she had purchased that, she had possessed that property. However, the number three is the registered owner, my lord.
3 is the registered owner.
Registered owner, yes, compromise decree was drawn by the learned trial court, my lord.
No, compromise is between whom? Registered owner and the,
Not the-
yourself.
Myself. Registered
That means
owner
1 and
myself.
3.
1 and 3,
1 and 3.
my lord.
And who is 2? Who is 2?
2.
What is the role of 2? Two is the purchaser.
Your
But
Lordship,
1 is the
Your Lordship.
applicant is also the purchaser. How many
Compromise.
purchasers are there?
Your Lordship, compromise agreement was made between respondent number 1 and 2,
One
not the
and two.
registered owner.
No, who is the registered owner? Number 3.
Yes.
Okay. Then who is number 2?
Number 2 is from whom I bought the building, and she is also the person responsible for making the compromise agreement.
You did not buy from the number 3. You bought it from number 2.
No, yes, my lord.
You did not purchase from the registered owner.
Yes, agreement was made between respondent number.
So number 2 is a
and myself.
middleman.
Not the middleman. She is the in actual possession of the building. Actually, she is
on,
the
on
actual
what basis?
owner.
On what basis?
Because number 3 has already sold the premises to the respondent number 2.
Number 2.
Yes.
Possessor of the building. She purchased from number 3.
Yes.
She had purchased from respondent number 3. That's what you're saying?
As per I was informed, yes, my lord.
No, right now I think everyone knows what is what. Respondent number 3 is the registered owner
Yes, my lord.
of the LSC.
Yes.
Number 2 is the possessor of the building and the property.
Although the landed property is in the name of the respondent number 3, but the respondent number 3 also has no interest in the said landed property, as she knows herself that the said land belongs to the respondent number 2.
On what basis? Number 2 has bought it.
Yes.
And you have bought the property from number 2.
Number 2, yes.
Okay. Then who is number 1?
I am number 1, my lord.
I know. What is your
Decree
role?
holder.
My lord, my role
Oh,
is that,
your civil suit.
yes.
On what basis? What,
My lord,
why-
my role is that the instant respondent number 2 had borrowed a certain amount of money from me. And a compromise agreement was signed on that on 4/04/07/2022 that a sum of 96 lakhs rupees will be repaid to me by the respondent, instant respondent number 1.
Okay. So you lend money to respondent number 2.
Yes. And she had represented herself before me that she is in possession of the landed properties which are the subject matter of the civil suit, my lord.
And who is the plaintiff?
Plaintiff in the civil suit is myself.
You're okay.
Yes.
Lend money to respondent. And she is the plaintiff. And the applicant has purchased the land from number 2.
Yes, my lord.
And my lord, if I may take your lordship to the impugn order, in my affidavit, this is at page number 19. The vernacular is at page number 19, and the English translation is at page number 19A. The property speaks differently, my lord. The property speaks differently, different property. The instant applicant had stated one property which is covered by LSC number 514 of 2005.
Just a
However-
minute. See, this is an application for condonation of
Yes,
delay.
yes, my lord.
Let me hear the applicant first.
My lord.
I was just trying to understand who are these people?
My
How are you all connected to each other? That's all.
My lord.
So right now, what I am supposed to consider is whether there's any good explanation for condone the delay.
My lord.
If there's no explanation, we'll dismiss it. If there is explanation, we'll condone it and hear the case on merit. You'll get your chance. Yes, please continue. You had taken me to page
Page 3.
3. You say that you came to know about the trial court's order on 4/4/24.
Yes, yes, my lord.
But again, you go back in time and say that in the month of March, some lawyer came to you saying that you may have to vacate the house.
Yes,
So that means in March you already know something is there.
something is there. But,
But about the order, you came to know only in April.
yes, yes, my lord.
Okay. Then you followed the opposite party number 2 to the court premises.
Yes, on 4/4.
Then what happened?
Come to realize that the opposite party number 1 had already won civil suit number 40 of 2023, and now an execution case number 16 of 2024 is pending before the court for payment. Hence, the applicant gained knowledge only after 195 days after passing order and decree, or 105 days after period of limitation. That after having such knowledge, the applicant engaged counsel, who firstly inquired the documents available on the courts, and after having some knowledge that the LSC number 796 of 2008, purchased by the opposite party number 1 from the opposite party number 2, is vacant land, and the two RCC buildings appearing in the compromise agreement dated 6/9/2023, signed between the opposite party number 1 and the opposite party number 2, and order and decree dated 25/9/2023 in civil suit number 40 of 2023, situated and located in another LSC. As such, the learned counsel firstly approached learned counsel for the opposite party number 1, with whom he had some discussion. And out of their conversation, it is also an admitted fact by learned counsel for the opposite party number 1 that if the RCC building was already purchased by the applicant, the opposite party number 2 has no right to give consent for transferring the same to any other person and could not mention in the said compromise agreement. Since the applicant is affected by the order and decree as well as compromise agreement, he is one of the necessary parties to be impleaded in the case, and in order to be implead as party, it is possible for the applicant to file review application before the same court. Besides, during the conversation, the learned counsel for the opposite party number 1 also fairly stated that if the personal inquiry is correct, filing of review petition may be good even for them to have affirmed and re-examining their case on its merits, and there would be no prejudice even for the opposite party number 2. Hence, the applicant filed review petition number 9 of 2024 together with CMA number 297 of 2024. Hence, the applicant thereby takes another 22 days. That unfortunately, the review court had dismissed the review petition by its order dated 26/9/2024, thereby pending before the court for a period of another 151 days. That after the court dismissing the review petition, learned counsel applied certified true copy of the impugn order on date 1/10/2024, and during such 1 week holiday puja vacation falls, and the same was finally issued on 16/10/2024 by taking another 20 days, and the learned counsel prepared memorandum of appeal, and for other of his works it takes another 5 days, and could file this application on this 22nd day of October 2024. The total period which needs to condone is 304 days. The reason, as stated in the above, is beyond the control of the applicant and is caused due to unavoidable circumstances. Hence, 304 days delay in filing appeal may be condoned for the interest of justice.
Where is the order regarding review petition being dismissed?
Your Lordship, Roman.
No, you are saying that at paragraph number 5, there was a puja vacation. Puja already, that's why, although you applied, it was finally issued on 16/10/24.
Yes, my lord.
Certified true copy. Where is that? Is it available in your RFA?
Yes, my lord.
Let us see. Page number. Why was it dismissed? Review.
M to R, page number M to R. It was dismissed on 26/9/2024. If I may take your lordship to page Roman number Q, para number 6. Para number 6 of the memo of appeal.
No, before that, you come to page M.
Yeah.
This is a format for certified copy. Date of application is 110. Date of making the order to the applicant is 310, only 3 days or 2 days.
Which vacation falls here.
Huh?
Which vacation falls here.
Vacation falls.
Yeah.
No, vacation falls, it does not it's not indicated here. Your paragraph number 5 of your application.
You
say that you applied for certified
actual
copy.
copy was handed over on 16.
How do we know that? Handed over on 16. Then why do they write 310? It says date of making over the copy to the applicant. This is the day on which is delivered to you. You have not explained that in your paragraph 5. You could have perhaps stated that although the certified copy was prepared within 2 days,
Yes, my lord.
but it was actually handed over to the applicant only on 1610, like that. Some explanation should have been there. How do we know that it was not handed over to you when the page M says that date of making over the copy to the applicant is 3/10/24? See, these are small things which you cannot ignore. Why was the review petition dismissed otherwise?
But the trial court stated the reasons in para 6 of its order. Had the councils and perused the records of civil suit number 40 of 2023, wherein order and decree dated 25/9/2023 were passed and drawn. On perusal of the compromise agreement, it appears that the plaintiff, herein respondent number 1, and the defendant number 1, herein respondent number 2, and the respective counsels, along with the counsel of defendant number 2, herein respondent number 3, have appended their respective signatures to the compromise agreement. The alleged sale letter executed between the review petitioner and the respondent number 2 is also perused, wherein the respondent number 2 had clearly stated that the LSC number so-and-so is registered in the name of the respondent number 3. It is a well-settled position of law that one cannot sell any property which he himself does not own. Therefore, the alleged sale of the building and LC by the respondent number 2 to the review petitioner is invalid, as the respondent number 2 is not the registered owner of the said LSC. A compromise decree which is vitiated by fraud, coercion, or misrepresentation, undue influence, or mistake can be recalled by the court under proviso to Rule 3 of Order 23 CPC. However, neither the review petitioner nor the respondent number 2 had pleaded nor argued that such fraud, coercion, or misrepresentation, undue influence, or mistake took place while executing the compromise agreement. A review petition may be made on any of the following grounds: discovery of new and important matter or evidence, or mistake or error apparent on the face of the record, or any other sufficient reason. The review petitioner has, in my considered opinion, do not make out any of the aforesaid grounds, and in consideration of the above discussions, this court is of the opinion that the petition is devoid of merit, and thus it is hereby dismissed without cause.
Okay, so,
Your Lordship, an additional affidavit has been filed on 28 February. And in the said annexure, there is a petition for a review along with its annexures. If I may read, Your Lordship. Para number 3 of the petition.
there was delay in filing the review. Delay was condoned,
Yes, it was condoned, yes.
Delay was
173
condoned.
days, yes.
but review was dismissed.
Yes, madam.
Now, what do you want to read?
The grounds taken by the review petitioner.
Where is that? Page?
Page, annexure, page, para number 3.
Para number
The petition, it is marked as annexure 1 in the additional affidavit.
Which page of additional affidavit are you referring to? It's not even paginated.
Para number 3, madam.
Para number 3 is only 2 lines, 1 line. It is humbly submitted, review petition number 9 of 24 was filed on 16/4/24. That's all. What is there to read?
Oh, my lord, I mean the annexures. Para number 3 of the annexures.
Which annexure?
Civil review petition number 9 of 2024.
See, you did not paginate your additional affidavit also. How was it accepted? And you notarize it outside. Anyway, read what you want to read.
That for the prevention of abuse of processes, the petitioner hereby filed this petition for review of the order and decree on the grounds inter alia. Roman number 1. Ordered the impugn order dated 25.
No, just a minute, Mr. Counsel. You don't have to read this ground. Why should we look into this ground at this stage?
Because
You're not filing an appeal against that review petition or something like that. So why should we look at the grounds of review? Your primary concern should be condonation of delay. You have to satisfy this court that there are grounds for condoning the delay. You are prevented by sufficient cause in not approaching the court to appeal in time. And the delay was bona fide. That you have to show. That's all. Why do you want to read the review grounds and all that? So let us go back to your explanation. You say that you purchased this land, property, on December 12th of 2022 from respondent number 2. And you did not know that he had already sold it to somebody.
no, compromise agreement was made only on 6/9/2023 after I bought.
6/9/23.
Yes,
Compromise agreement.
compromise agreement. Based on the compromise agreement, the decree was drawn.
Where's the compromise agreement?
But Roman number 3 of my application. English translation is at 3A.
Just a minute, purchase from. Purchase by opposite party number 1 from opposite party number 2 is vacant land. In the occupation. Compromise agreement. Compromise agreement between whom? 1 and 2.
1 and 2, yes, my lord.
Dated 6/9/23.
Yes.
So let us go to the decree itself. What does it say? Does it say that based on the compromise? Take me to your additional affidavit. You have annexed something here?
Your
Decree?
lordship,
Decree?
decree is at page Roman 9 of my application is the decree.
Page Roman 9 of?
Roman 9
Of
my application.
which application?
Condemnation application.
Condemnation application.
Yes.
Okay.
From page, start from
Roman
page number
9.
7. Roman 7. Number 9 is the operative portion.
No, just show me that line where it says that the decree is on the basis of the compromise.
Para number 4, sub 1, that based on the compromise agreement dated 6 September 2023, defendant number 1 shall make payment of rupees 50 lakhs before the end of February 2024 to the plaintiff. During this period, the two buildings, new building being occupied by the defendant number 1 and another adjacent building where the defendant number 1 used to stay, located at checkbox shall not be.
Just a minute. From where are you reading?
Para number 4,
Of what?
page Roman 9.
In your IA for convention of delay?
Yes, my lord.
Give him this. Just show me. I have not seen that. What is this? This is a part of the order? Decree?
Yeah, decree, yes, my lord.
Then where's the judgment? Same thing.
Yes, my lord.
Uh,
Roman 1 is the order and Roman 7 is the decree.
It starts from Roman 1, correct?
Yes,
Order dated 25 September.
yes, my lord. And decree is Roman 7.
So court has not adjudicated. There's no adjudication.
Yes, my lord. Para number 3 states that whilst proceeding with the case at the stage of filing of a written statement, receive a compromise agreement dated 6 September 2023 on 6/9/2023.
From where are you reading that?
Para number 3 of page Roman 9. So,
While proceeding with the case at the stage of filing WS, received a compromise agreement dated 6 September 2023. It is therefore ordered and decreed by the court as so and so. So what is the compromise about? In short, compromise between whom?
compromise-
plaintiff
the plaintiff and the plaintiff, the respondent number 1 herein, and the respondent number 2.
Okay. One, number 2 also.
Number 2, yes.
Compromise between the plaintiff
And the defendant 1.
and defendant number?
1.
No, plaintiff is respondent number 2, Ram Ex-gratia. She is the plaintiff.
No, respondent number 1 is the plaintiff.
That is what I'm saying. Ram
my lord.
Ex-gratia is respondent number 1. She is the plaintiff.
Yes, my lord.
So compromise is between respondent number 1 and
2.
2,
Yes, my lord.
the one who possess the land.
Yes.
3 is the
However, on this particular date, on this particular day of making the alleged compromise agreement, I was in possession of the said building.
because according to you, you had purchased the land.
Yes, on December 12, 2022.
What evidence do you have about your purchase?
Your Lordship, my additional affidavit, the annexures is the petition for review, along with the annexures.
What are you saying?
Petition for review along with its annexures. I have submitted in my additional affidavit.
And which is that annexure?
Annexure, and annexure
5.
5, yes, is the sale agreement. Part payment was made, Your Lordship.
You have purchased from whom?
Respondent number 2.
From respondent number 2. But does it say like that? Under what authority has the respondent number 2 sold his land? He is not the registered owner.
She was in actual possession,
But you also know that she is not the registered owner.
but
Yet you purchase it from her.
as per the agreement, mutation will, steps will be taken up by the defendant number 2. So formal sale letter would be made after paying of the remaining balance.
You have given 15.
30,
Huh?
35. Balance of 15 is to be paid.
You sold it, you have bought it for 50.
Yes.
Initially you paid 35.
Lordship. 1 minute.
Agreement was for 50. You paid 35, leaving a balance of 15. Have you paid the entire 15 also? Not yet.
my lord.
Not,
Yes,
not paid.
because suit is pending now.
Now tell me, how does the respondent number 2 make a claim on this building, although LSC is not in her name? On what basis?
She divides the landed property in three plots, 3 different plots. LSC, which under LSC number,
No, who divided the property?
respondent number 2.
On what basis? She's not the owner of the land. It's not her name.
She's taking steps, I think.
Huh? She's taking steps.
Yeah.
On what basis? Two and three are related to each other.
No, my lord.
They are not related.
Yes.
So,
But number 2 already admit that she had sold the property to respondent number 2.
on what basis? Okay, we don't say that she has not sold it, but on what basis has she sold? She's not the registered owner. You have bought the land from a person who is not even the registered owner. So question is that whether there's any claim can be made by you, merely because you paid some money. You have not even annexed a translated copy of this Annexure 5.
Lordship,
Huh? Supposing it was a different code, they will not be able to read.
allow,
Hmm?
allow me to insert the translation copy.
Now,
Read, sir.
at this stage.
Yeah.
Read the vernacular. Let's see what is written here.
Boy ni som panhi tha som panhi san ni som ni panhi yan ka building LSC 102/12/01/514 of 2005 ke vanlal thria ti minga plot number 108 na hi ulal travel amol pui ne na che noi somnga in ka sala noi som thum panga kadong hala noi som panga balance somani a balance lom hi pension suwa huna in lan pel turing kanin rem siamani aram tender le pulal travel minga LSC tura malak hi chu silen khumi mo purna ni ang
Who is Lal Travela?
the applicant, the petition, the plaintiff.
Okay.
Oh, the applicant.
So, reading the first line itself, he says, my building. Yet he says, it is in the name of somebody else. Can there be 2 owners for that building and the land?
Your Lordship,
You know very well that this is not his land, her land. You bought it. Why did you land yourself into such trouble when you know that it is not the land of that person?
I was assured that steps will be taken by the respondent number 2, as she was the possessor of the said landed property.
Okay, now
And
that,
LSC number 105 this LSC is divided into 3 plots. Here it is stated that plot number 18 or 108 nahi pulal travel nen akasalaki. It also stated here.
that LSC was divided into 3 plots.
Yes, my lord.
You have purchased 1 plot.
Yes.
Okay. Now you tell me, what is the relationship between 2 and 3? Respondent number 2 and 3.
Respondent number 3 is only the registered owner. The registered owner, the owner of the revenue report. of the landed property.
She is the registered owner. So what business does the respondent number 2 have to sell her land?
Your Lordship, that I was assured that steps will be taken by the respondent number 2 before the review.
Who assured you? Who assured you?
Respondent number 2
On what basis?
that she was the actual owner, and respondent number 3 has also agreed to that.
How do you know that she's agreed?
As per my knowledge, she was telephoned before making a sale transaction.
You're making a big risk. I don't know. How did you just simply, somebody assures you, I've got one LAC. It's in the name of somebody else.
Yes.
You buy it from me, I will see that you get this land, then you purchase.
Yes.
And how can you buy things like that? So the transaction happened on 12/12/2022.
22 years.
Agreement happened on
Compromise agreement on 6/9.
6/9. This is in the judgment or the decree. Compromise agreement between the defendant or respondent number 1 and 2, correct?
Yes.
You were kept in the dark. You did not know about this.
Yes, my lord. I came to know only on April 4th.
Okay. Any decision you would like to rely upon?
Yes, my lord.
What is that?
Yes, submit this one. First is my lord. I bring 3 judgments. First one is 1998 SEC 123 M. Balakrishnan versus M. Krishnamurthy,
Paragraph number?
12 and 13. Should I read, my lord?
Come to that straight away.
The last portion, third line, the last portion. This court has held that the word sufficient cause under Section 5 of the Limitation Act should receive a liberal construction so as to advance substantial justice. Vide Shakuntala Devi Jain versus Kuntal Kumari and State of West Bengal versus Administrator Howrah Municipality. Para number 13. It must be remembered that in every case of delay, there can be some lapse on the part of the litigant concerned. That alone is not enough to turn down his plea and to shut the door against him. If the explanation does not smack of malafide or it is not put forth as part of a dilatory strategy, the court must show utmost consideration to the suitor. Lordship.
Next.
Next is to 2025 SCCR 295 or 2025 INSC 53. H. Guruswamy and others versus A. Krishnaya, since this is by LRS.
See, next time you have this compilation, correct?
Yes, my lord.
next time make the habit of paginating it,
Yes, ma'am.
so that you can say
Oh,
page
I'll-
number 10. I can turn
Yes.
page number 10.
Okay, ma'am.
Page 20, page 20.
Okay.
Now I have to find out where is where. So,
I only numbered on the first page, number 1, 2, 3.
no, that is not sufficient. Giving an index is not sufficient. You have to paginate the entire contents. Now, you are referring to which paragraph?
Paragraph number 15, 16, and 17.
Please read.
15. The rules of limitation are not meant to destroy the rights of parties. They are meant to see that the parties do not resort to dilatory tactics but seek their remedy promptly. The length of delay is definitely a relevant matter, which the court must take into consideration while considering whether the delay should be condoned or not. From the tenor of the approach of the respondent herein, it appears that they want to fix their own period of limitation for the purpose of instituting the proceedings for which law has prescribed a period of limitation. Once it is held that the party has lost his right to have the matter considered on merits because of his own inaction for a long, it cannot be presumed to be non-deliberate delay, and in such circumstances of the case, he cannot be heard to plead that the substantial justice deserves to be preferred as against the technical considerations. While considering the plea for condemnation of delay, the court must not start with the merits of the main matter. The court owes a duty to first ascertain the bona fides of the explanation offered by the party seeking condemnation. It is only if the sufficient cause assigned by the litigant and the opposition of the other side is equally balanced that the court may bring into aid the merits of the matter for the purpose of condoning the delay. We are of the view that the question of limitation is not merely a technical consideration. The rules of limitation are based on the principle of sound public policy and principles of equity. No court should keep the sword of Damocles hanging over the head of a litigant for an indefinite period of time. Your Lordship, my next
Your next is what? Mool Chandra.
motion,
Paragraph number.
paragraph number 26th line.
Yes, read.
It is not the length of delay that would be required to be considered while examining the plea for condemnation of delay. It is the cause for delay which has been propounded will have to be examined. If the cause for delay would fall within the four corners of sufficient cause, irrespective of the length of delay, same deserves to be condemned.
Okay. That's all?
Yes, my lord.
These are your three cases.
Yes.
So let me hear the other side. 2 and 3, they have no objection. 1 has objection. So, Mr. Kima,
May it please your lordship. My lord, the rulings relied on by my learned friend, I don't think, my lord, in my humble opinion, that is beneficial to his case. Because, my lord,
that is beneficial to his case.
it's not, I seriously doubt it is beneficial to his case. Because,
Why?
my lord, the cause of delay will have to be considered on the explanation given by, in his application. And which perusal of the application itself will indicate that no sufficient explanation has been given. And that, my lord.
No, he has come to know lately.
Yes,
Explanation is that he's come to know lately. First of all, he tried to file review.
my lord,
Review was pending for 100 plus days.
my lord,
Review was dismissed, so he had to come to this court.
my lord, my lord. And my lord, on the merits, my lord,
No, we are not on merits. We are on the delay condemnation.
on the merits of the application, my lord. If, my first objection is that the applicant was aggrieved that the landed property in question is LSC number 514 of 2005. However, my lord, perusal of the order impugned by the applicant will clearly indicate that the landed property is entirely different. The subject matter of the
Okay, show me that.
yes.
How is it different?
My lord, if your lordship will,
We are concerned with plot number 108.
my lord,
Plot number 108 under LSC number 1025 of 2000.
514 of 2005. Yes. However, my lord, if your lordship will come to page number 23 of my affidavit.
No, let us concentrate on this first. You come to the additional affidavit. Do you have a copy of the additional affidavit? Applicant's counsel also, please go through that. Let us identify the LSC which you bought.
Yes, my lord.
Building in Lena, this one, Annexure 5.
Annexure 5.
LSC number 1025. Then,
Plot number 18. 108.
what is the LSC number? There's so many numbers here. 1025 oblique 112 oblique 01 oblique 514 of 2005.
Actually, that is how
514
the
is
revenue department made the record. The 514 is the actual number of LSC.
514 is the actual number.
Yeah.
Yes.
And plot number is 108.
Yes, my lord.
And Mr. Zekima, what are you saying? You're saying that this is not the one.
Yes, my lord. The landed property in the subject matter in the civil suit, my lord, this is LSC number 796 of 2008.
Where is that? Show me. From where?
My lord, this is at page number 20
Of page of what?
of my affidavit, my lord.
Your affidavit.
Yes. It starts from page number 16. This is the impugned order, order dated 25,
Page number. Don't be in a hurry. Page number
page number 16.
16 of your affidavit.
Yes,
In opposition.
yes.
Yes. Which one?
This is the impugned order. And even at the first paragraph, number 1, on the second line, it is also clearly reflected that the two RCC buildings and land covered by LSC number 796 of 2008.
Okay. So this is the number.
Yes, my lord.
Now where is the LSC?
Subject matter is entirely different, my lord.
Where is the LSC? Any copy of LSC annexed?
No, my lord. Copy of LSC I have not annexed. However,
If subject matter is entirely different, what is your objection then? Why do you object?
and my lord, that the applicant should not be allowed to file the instant appeal along with the two applications, whereas he had disputed one property, which is not the subject matter of the land in dispute before the civil court. My lord.
Just a minute. (796) of 2008. There's something which is much more complicated than what you people are saying. Shifting of location, area location and all that. I don't know. So many buyers here and there.
And my lord, even assuming,
No, let us read.
yes,
I want to understand your case. You read, this is a civil suit. Read from that order.
my lord. This is a civil suit number 40 of 2023 filed by the plaintiff for declaring that the two RCC buildings and the land covered by LSC number so-and-so belong to the plaintiff by virtue of registration certificate dated so-and-so in sale deed bearing document registration number so-and-so. Also for declaring the RC building occupied by the defendant number 1 and its adjacent RCC building are belonging to the plaintiff, as both the plaintiff and the defendant number 1 executed poisapuk chungchanga in Remanding dated 25/03/2022. Also for declaring that the RCC building occupied by the defendant number 1 and its adjacent RCC building located at Chekbok, Ngaizel, Aizol are belonging to the plaintiff if such two buildings are not covered by LSC number 796 of 2008. Also for eviction of the defendant number 1 and her family from RCC building presently occupied by them located at Chekbok, Ngaizel, Aizol, Also for directing the defendant number 1 and her family to shift away from the RCC building presently occupied by them, which is covered by LSC number 796 of 2008 located at Ngaizel, Aizol. Also for directing the defendants not to relocate the area of LSC number, now the subject matter of the,
That's what.
this comes. And also for directing the defendants not to relocate the area of LSC number 1025/12/01514 of 2005, thereby shift into the area of LSC number 796 of 2008 located at Tsekbo, Ngaizel, Aizol, as LSC number 796 of 2008 is belonging to the plaintiff.
Okay, so this LSC of 514 is to be relocated
Yes, my lord.
and shifted into LSC number 796 of 2008.
This, my lord, we have prayed that this LSC number 514 of 2005 should not be shifted and relocated in the location of LSC number 796 of 2008.
Why is the relocation required?
My lord, there are two LSCs. And in fact, my lord, if I may take your lordship to page number 15, page number 14.
Of your,
Page number 14 of my affidavit in opposition. This is in not. This is the Xerox copy, which is not very clear, and I have annexed the typed copy at page number 15. Page number 15. This is in respect of LSC number 514. And this, it is reflected that this supersedes previous House Pass number 311 of 99 in favor of Tluang Lian Thanga, son of Aishrima.
what is this? Page 14?
Page 14, this is, my lord, the boundary description of the LSC 514 of 2005.
Where is it 514?
514, my lord, it starts from page number 11.
Okay, 11, right.
Yes.
See, what do you want to show?
My lord, what I want to show is that the entire history of LSC number 514 of 2005 and LSC number 796 of 2008, these are different, entirely different, my lord. In fact, in the additional affidavit filed by, in the review petition filed by the applicant herein before the learned trial court, he had annexed copy of this LSC number 796 of 2008. And the history of the set LSC, my lord, these are also entirely different. It says that the set pass, Heram hi H house pass number 748 of 2004, atanga Silian Kumi Minga LSC Asiam, Ram Eng Zwali Minga Tlakani. My lord,
Seven nine six of 2008.
my lord,
And on the other hand, 514 of 2005.
my lord.
How are they connected to each other?
My lord, in so far as our humble consideration, these are not related, my lord. These are entirely two different properties in different locations, my lord. And that,
But yet you pray
yes,
in your civil suit
my lord,
for directing defendants not to relocate
my lord,
514 to 796.
my lord.
Why was the requirement for relocation?
My lord,
Then if you relocate this 514, if a 514 is relocated to 796, then what will happen to 796?
my lord, then
They're supposed to be interchanged, or what?
no, my lord, then that would mean that my pass, my LSC will have been superseded by the 514 of 2005.
Okay. Your pass 796 of 2008,
8. Yes.
it has originated from 514 of 2005.
No, my lord. My pass has originated from a house pass.
House pass.
Yes, which was mutated and issued as an LSC in the name of the instant respondent number 2, which thereafter was mutated in my name in the name of the respondent the instant respondent number 1.
You call the Jamadar. Yes, please come again.
My lord,
How is it connected? 796 and 514.
my lord, the instant respondent number 3. The instant respondent number 3 had claimed that the which in my civil suit I have impleaded as a as a defendant number 2. She had claimed that her landed property is situated in the similar location as my landed property. That is why we have.
So in one location, 2 LSCs have been issued.
Yes, that is the contention of
Overlapping.
Yes,
It's overlapping.
that is the contention of the instant respondent number 3.
It may be yes or no,
Yes,
but,
madam.
but according to the allegation or the averment, it is
Yes.
overlapping.
According to the allegation of the instant respondent number 3.
Okay.
Yes.
So that means there is some bearing on it. It is not that it's something else way out of like some different, totally different place which has been claimed.
Madam.
It so appears that both the locations are like maybe of the same area.
And
So
however,
so it's better to hear on merit what is
How-
to be done.
however, my lord, the perusal of the history of the 2 LSCs, they're entirely different.
That will be decided on merit when the merit comes. See, you have an objection, correct, but I think we should hear the matter on merit. Mr. Zekima. You will not be deprived of your chance to argue on merit. You will be arguing on merit for rejection of the appeal or for dismissal of the appeal, whatever.
My lord.
But right now, basically, court wants to know why delay has happened. He has shown that he was not aware about it and there was some agreement or compromise made behind his back. When he came to know, he tried to file review but did not succeed. So he had come here. End of the day, it's 304 days delay.
If I may, my lord, if I may take your lordship kindly to page number 18, which is at paragraph 2
Of your,
of my affidavit, my lord. The learned trial court had reproduced the compromise agreement. If I may read paragraph number 5, this is the vernacular.
read.
If I may read the vernacular, my lord. Tuna PC lian kumichen make na building, bula building, check book I hian chung pua. Kosa make an oma hemi ten na hian PC lian kumi he building hi asal lova ba aya ni tum ani loboka an chung te ani awanga anom tirve mai ani thu PC lian kumi hian kota anim hi ani bokani. So, my lord, even if assuming that the claim of the instant appellant that he had bought the property, however, my lord, this had been clearly stated and considered before the learned trial court, my lord.
Okay, but the applicant was not a party at that time.
My lord.
He's not aware about these things. That's why. All right, we'll consider and dispose of that. We argue on merits.
My lord.
Please write down. Heard, Mr. Lalbiak Tuama.
Yes, my lord.
Learned counsel for the applicant. Then Mr. Tilal Zakima for respondent number 1. Mr. Lal Raku Mapatu for respondent number 3. And Miss, sorry, Katrina, Gina Vanal Swai for respondent number 2. Please give in a piece of paper your names. Mr. Ruku also, so that we don't have difficulty here. Stop. By filing this application, the applicant seeks condonation of 304 days delay in filing the connected regular first appeal. Against the order dated 25/9/2023, passed by the Court of Civil Judge, Senior Division Roman 3, Aizawl, in civil suit number 40 of 2023, and also against the decree drawn on the same date. Stop. Learned counsel for the applicant, by referring to the application, submits that the applicant purchased one RCC building covered under LSC number 1025/12/01/514 of 2005 on 12/12/2022 from the respondent number 2. At the cost price of rupees 50 lakhs, थोड़ा बाद में आएगा. Ask him to go. थोड़ा बाद में आएगा. Dictation दे रहा हूँ. At a cost price of rupees 50 lakhs, and the applicant had paid 35 lakhs in advance, and the balance of 15 lakhs was to be paid later on. Stop. According to the applicant, he was not aware about a civil suit pending before the trial court, that is civil suit number 40 of 2023, filed by the respondent number 1. Stop. According to him, he came to know about the order and decree passed by the trial court on 25/9/2023, only on 4/4/2024. So he also came to know that pursuant thereto, the respondent number 1 had filed execution case number 16 of 2024, and the same was pending before the court. Stop. The applicant further came to learn that the order and decree was passed by the trial court based on a compromise agreement reached between the respondent number 1 and respondent number 2 on 6/9/2023. Whereas the applicant had purchased the building from the respondent number 2 on 12/12/2022. Stop. The applicant therefore sought for legal advice and engaged his lawyer who took steps for filing a review petition along with an application for condonation of delay. Stop. CM application number 297 of 2024. Is that correct? 297 of 2024
Yes, my lord.
was filed for condoning the delay in filing the review petition. And the review and the application was allowed. What is the date of the order? Delay condonation.
Twenty-nine. Oh.
Delay was condoned by which order? Give me the date, okay?
Yes, my lord.
Condone the delay of the review petition. And the delay was condoned by order dated so and so. Stop. However, the learned trial court, upon considering the review petition, by order dated 26/9/2024, dismissed the review petition. Stop. The petitioner thereafter made preparation for filing the instant appeal. But however, filing the instant appeal, and accordingly, the appeal could be filed on 23/10/2024. Stop. The learned counsel submits that in filing the appeal, a delay of 304 days has occasioned. But the reasons for the delay are not on account of inaction or negligence on the part of the applicant, but for bona fide reasons. Have you got the date? Delay condonation of the review?
20. Yes.
Next para. The learned counsel, in support of his submission, that court should construe the word within inverted comma sufficient cause with liberal construction so as to advance the cause of justice subject to there being no malified on the part of the applicant, as relied upon the case of N. Balakrishnan versus M. Krishnamurthy, reported in 1998, 7 SCC 123. Most of the learned counsel also has relied upon the case of H. Guruswamy and others versus A. Krishnaya, since deceased, by LRS, reported in 2025 INSC 53, to contend that the rules of limitation are not meant to destroy the rights of the parties, and that the parties do not resort to dilatory tactics but seek their remedy promptly. Stop. The learned counsel submits that the applicant has been able to demonstrate that he had taken all necessary steps upon gaining knowledge about the passing of the order by the trial court in the civil suit, and hence the delay may be condoned. And hence the delay in filing the connected appeal may be condoned. Stop. The learned counsel has also relied upon the case of Mool Chandra versus Union of India and another, reported in 2024 INSC 577. This is the compilation. Next para. Learned counsels appearing for the respondent numbers 2 and 3 submits that they have no objection if the delay is condoned. Stop. Mr. T. Lal Zakima, learned counsel for respondent number 1, however, submits that the petitioner has the applicant has miserably failed to explain the delay with sufficient cause. Stop. He also submits that the citations, the authorities relied upon by the applicant's counsel are in fact not in his favor, but against him. Stop. He further submits that the applicant cannot be said to be party aggrieved in view of the fact that the subject matter of the civil suit was in respect of LSC number 796 of 2008. Whereas the claim of the applicant is in respect of
LSC 514 of 2005.
LSC number 1025/12/01/514 of 2005. Stop. He therefore submits that no grounds for condone the delay has been made out, and the application seeking condonation of delay for filing the connected appeal should be rejected. Next para, I have heard the submissions made by the learned counsels for the rival parties, and I have produced the materials available on record. Stop. The claim of the applicant is that he had purchased the RCC building standing on the LSC in question on 12/12/2022 from the respondent number 2. Stop. However, civil suit number 40 of 2023 was filed by the respondent number 1 against the respondent number 2 and 3 before the Court of Civil Judge Senior Division, Roman 3, Isol. And the said suit came to be disposed of pursuant to the compromise agreement dated 6/9/2023, signed between the respondent numbers 2 and 3.
1 and 2, my lord.
I'm sorry, respondent numbers 1 and 2. That is good sign that you are paying attention. Okay. Then, as regards the submission that the LSC, which was under consideration before the trial court, was in respect of 796 of 2008 and not the LSC which the present applicant claims. It may be seen that one of the prayer made in the civil suit was for a direction to the defendants in the civil suit not to relocate the area of LSC number 1025/12/01/514 of 2005 into the area of LSC number 796 of 2008. Stop. Therefore, it cannot be at this stage determined whether the claim of the applicant would not have any bearing in respect of LSC number 796 of 2008. Stop. All that the court, all that the court is concerned with at this stage is with regards to the delay in filing the connected appeal. Stop. Considering the explanation standard and the authorities relied upon by the applicant's counsel, this court is of the considered view that the applicant has been able to explain the delay in filing the connected appeal with sufficient cause. So accordingly, the delay of 304 days in filing the connected appeal stands condoned. IS stands disposed of as allowed.
Deeply blessed. Lordship, date is 29/4/2024.
Okay.
Review court conduct.
Dash, na? Somewhere, condonation of delay of the review petition. Date is
29/4/2024.
29/4/2024. Then you write in the there's one more application, isn't it?
Yeah, yes. Leave
17A,
application.
What do you say about the leave?
My lord, we have objection, my lord.
You have objection?
Yes,
Okay, we'll post it some other day.
my lord.
In IA number 178 of 2024, please write like this. In view of the order passed today in IAC number 177 of 2024, condoning the delay in filing the connected appeal. List this application along with the main appeal. When?
After 1 week.
After 1 week, my lord.
After 1 week. Okay.
Obliged.
Obliged.
We have to take a short break. What is that? Disposes 177. I'll just take a short break and come back.
Item 9.
Yes, may it please your lordship, I am here for the appellant, my lord. And yes, lordship, we have received the paper book. So if this matter may kindly come up for hearing list, my lord.
Okay, learned counsel for the parties submit that they have received the paper book. You have received also,
Yes, my lord.
and that the matter can be listed for hearing. And submit that the matter can be listed for hearing. Stop next paragraph in view of above. Registry lists the matter for hearing as per its own turn.
Deeply obliged.
Item 10.
May it please your lordship.
Yes,
My lord, it was observed on the last court that if the respondent are not represented today, Lord, attempts will be made to
how many
dispose of the-
respondent?
Only one, my lord. In
How
fact,
many days delay?
there's a delay of 1,782 days.
Okay, only one respondent.
Only one respondent.
Notice has been served.
Yes, and my lord, provide order dated 20/01/2026. Notice was deemed complete, my lord.
Okay. How have you served? By way of Dasti?
Yes, my lord. We have filed affidavit of Dusty's service on 18/11/2025.
When did you serve the notice?
My lord, step was first taken on 28/08/2025.
I think you have served the copy on 17/11/25.
Yes. On 18, we have
Paragraph
filed,
3 of your affidavit on Dasti.
my lord.
Is that correct?
My lord.
You have personally served to the respondent
Yes.
on 17 November
Yes, my lord.
2025
My lord.
in presence of 2 witnesses. But you should have given the date, isn't it? There's no date on at page 5 of the acknowledgement notice. Anyway, court has presumed. So, what is your explanation?
My lord, the explanation is that I was not aware that the respondent, the applicant and the respondent are siblings, my lord. They are brother and sister. They are brother and sister.
Appellant and the respondent.
Yes. And that I was not informed that my brother, the respondent, had applied for issuance of heirship certificate. And I came to know of the issuance of this certificate, my lord, only through RTI application that I have submitted before the Revenue Department. On 25/04/2025,
What is that date?
on 25/04/2025, I was given a reply by the Revenue Department.
No,
that-
no, you
Yes,
go in sequence. Please go in sequence.
my lord.
See, first of all, you are challenging the heirship certificate case number of 868 of
868 of 2018. Date of
Okay.
order date is 20/07/2018.
Where have you highlighted? Okay. Then, when did you come to know about this?
My lord, I came to know about this only on 25/04/2025.
Where have you stated that?
That at page number 4, Roman 2. Roman 2, I came to learn of the issuance of heirship certificate in the month of April 2025,
Then, what did you do?
and I immediately approached the concerned revenue department, who is the competent authority in respect of LSCs, landed properties, LSCs. And I was informed by the SPIO of the said revenue office on that the LSC number 147 of 1973 has already been mutated in the name of my brother.
Okay, then?
And my lord, this is at annexure number 2. However, in the annexure number 2, my lord, since I was not issued any copy of the heirship certificate, or I was not given details as to which court had issued that heirship certificate, I again applied for an RTA application, and I was given a reply on 9 July 2025.
When did you apply?
My lord, the date is not given, my lord.
You said you again applied.
Yes,
You don't know the date. But you know the reply.
my
9
lord,
July.
my lord. And in the reply, my lord, I was also given the connected documents. Heirship certificate copy I was given.
When was the reply given to you? On 9 July.
On 9 July. On 9 July 2025.
Then?
And as soon as I came to learn of this, I sought a legal advice who had advised me to take steps for issuance of certified true copies of the connected documents. And my lord, I was furnished copies on 05/08/2025.
Where have you mentioned that?
This I have mentioned at paragraph Roman 6, page number 6. Page number 6, Roman 6.
When did you apply? When did you get? Please organize your drafting,
My lord,
Mr. Zekima.
my lord.
We just know what the dates, that's all. You don't have to describe each and every document in paragraphs.
My lord. And my lord,
When did you apply the certified copy?
my lord, this has not been reflected in the.
So we have to use our own imagination. It's not reflected.
My lord, application is sought on 29/7/2025. This is reflected in at the first page of the RFA. RFA, the main RFA.
Then when did you get?
My lord, I would receive the same on 05/08/2025.
Then
And on careful perusal of the heirship application, my lord, it was discovered that the instant respondent had made a false submission before the.
no, you applied for the heirship order, or you applied for a heirship application?
My lord, all of them,
All of them?
yes.
Okay.
The application, the connected documents, as well as the heirship order and the heirship certificate.
Then what happened? What happened?
My lord, I discovered that my brother, the respondent herein, had committed a fraud and made a false submission before the learned trial court for issuance of the heirship certificate. He had stated, if I may take your lordship to page number 29, annexure 4.
Yes, what did he state? Tell
He
me
had
that.
stated, paragraph number 4, he had stated that he had only one surviving sister who was married and who had returned back home. That was myself, the applicant. However, I have another sister who is still presently residing at Ramthun, at Ramthar North,
Married.
married and living, maintaining a separate household.
Okay.
This I have annexed it, annexure number 5, page number 33.
So you have how many? 2 siblings?
Yes, my
One brother, one sister.
lord.
Your brother says that he has only one sister,
Only one sister.
that yourself,
Yes,
who got married and returned back.
yes.
You both are staying separately?
Our house within the LSC is a two-storied building. Prior to the death of my mother, myself and my mother used to live on the upper floor. And my brother, the respondent herein, had married and lived in a rented house at Dintharu.
Brother.
And, yes. And after living there for quite some time, he had returned back home.
Brother?
Yes.
Brother returned back.
Yes, in the main house.
But he says that you returned back.
That is also true, my lord. While he was...
You got married
Yes. I got married.
and then you returned.
Yes.
Got divorced or what?
Divorced, my lord.
He got divorced, he came back.
Yes.
He also lived separately, then he came back again
came
to the
back
house.
again.
All of you are living together.
Yes.
Then behind your back, he applied for heirship
Yes.
certificate.
Yes, my lord. And during the lifetime of my mother, when the respondent, along with his family, had returned back to the main building, the upper floor where we were previously staying, my mother and myself were previously staying, was a larger room. So in order to accommodate the respondent and his family, who is a larger family, my mother let them live on the upper floor, whereas my mother and myself lived on the ground floor. And after the death of my mother, without informing myself or my other sister who had married and maintained a different household, the respondent had applied for heirship certificate.
Okay, as of now,
Yes,
the LSC has been registered in the name of your brother,
my lord.
converted
My lord.
on the strength of the heirship certificate.
Yes, my lord.
So on discovery, you applied for this
Yes,
RTI application. You found that this is what has been disclosed.
my lord.
Then you filed this appeal.
Yes,
When did you file the appeal?
my lord. The instant appeal was filed on 19/08/2025.
Then? That's it.
Yes, my lord. That is my ground, my lord. So the grounds taken for delay now.
So we should reject your application.
My lord, no, my lord. My humble submission is that let this delay be condoned, and that I may be allowed to contest the case, my lord.
All right, please write down. Heard Mr. T. Lal Zakima, learned counsel for the applicant, who submits that by filing this application, the applicant seeks condonation of 1782 days delay in filing the connected regular first appeal against the order dated 27/2018, passed by the Court of
Senior
Senior
Civil Judge.
Civil Judge
3, Aizol.
3, Aizol, in heirship certificate, case number 868 of 2018. Stop. The learned counsel submits that despite service of notice upon the sole respondent by way of dusty, as permitted by this court, on 17/11/2025, the respondent has failed to appear before the court. And this court, white order dated 21/2026, had accepted the notice to be complete upon the sole respondent. While fixing the matter again on 5/2/2026. Stop. When the matter was listed on 5/2/2026, the sole respondent failed to appear, but this court again adjourned the matter for 2 weeks to enable the respondent to appear. Stop. However, the respondent number 2 has failed to appear before the court till date and submits that the delay in filing the connected appeal may be condoned. Stop. Next para, referring to the application, the learned counsel has drawn the attention of this court to the statements made therein. More particularly at paragraph number 2, wherein explanations have been made with regard to the delay in filing the appeal. Stop. The learned counsel submits that the applicant came to know about the LSE in question, that is LSE number 147 of 1973, being mutated in the name of the respondent, who in fact is her brother. He is elder to you or younger to you?
Younger to me, my lord.
He is her younger brother. Stop. He submits that the applicant therefore submitted an application on under the RTI Act to the Revenue Department and in response to the same, the petitioner was informed that the LSE has been mutated in the name of the respondent on the strength of the heirship certificate issued in his favor. Stop. The information was given to the applicant, via letter dated 25/4/2025. But there was no mention as to which court had issued the heirship certificate, and therefore the applicant once again submitted another RTI application seeking the details of the petitioner. The applicant was accordingly informed about the court which gave the heirship certificate along with a copy of the said order via letter dated 9/7/2025. Stop. The petitioner then consulted her lawyer on the matter, and she was advised to obtain all the relevant documents pertaining to the heirship certificate case. The applicant therefore submitted one more application for asking for copies of all the relevant records and orders in respect of the heirship certificate application. Stop. The same came to be furnished to her on 5/8/2025. Whereafter, the applicant, through her lawyer, prepared the connected appeal and filed the same on 19/8/2025. To stop. The learned counsel submits that by that time, there occasioned a delay of 1782 days in filing the connected appeal. To stop. He submits that since the delay was due to lack of knowledge about issuance of heirship certificate to the respondent and the steps taken thereafter by the applicant to obtain necessary information and to file an appeal, which caused the delay. To stop the same being due to bona fide reasons, the learned counsel submits that the delay may be condoned. Next para, having considered the submission and upon perusal of the application and the statements made therein, I am of the view that the applicant has been able to explain the reasons for the delay satisfactorily. Accordingly, the delay of 1782 days in filing the connected appeal stands condoned. IS stands disposed of as allowed. In the main appeal, in view of the order passed today in IAC number 141 of 2025, list the appeal for consideration after a week.
Deeply obliged.
Item 11.
Yes, Mr. Lomama.
Yes, my lord, the respondents will appear.
My lord, we have received instructions to appear on behalf of both the respondents and will be filing our power by next week.
Okay. What order has been passed so far?
My lord, the appeal has been admitted in the last court date and the TCR is also called for, but not yet arrived.
Not yet arrived.
Yes, my lord.
Okay. Please write Mr. Lomo Moralte, learned counsel appears for the appellant, and Miss
Val Thamwani.
Valal Thamwani, learned counsel, submits that she has instructions to appear on behalf of respondent numbers 1 and 2, and that she will be filing her power
By next week, my lord.
within a week. How many respondents are there?
2, my lord, only 2.
Okay. Have you taken steps otherwise?
Yes, my lord.
Okay. Considering the same, the notice is accepted to be complete on the respondent numbers 1 and 2. List the matter again after a week, awaiting the TCR.
Obliged, my lord.
For admission, item 2.
Please, Your Lordship.
Yes.
Lordship was pleased to inquire yesterday about the status of the draft award and as to whether the LAR authority has been constituted, my
Oh,
lord.
this is that case. Yes, Mr. Samuel.
Yes, my lord. If I may please your lordship, as far as my instruction is concerned, my lord, the draft award 1 of 2024, my lord, which was approved on 27th of March 2024, my lord. This has been finalized, and as per my instruction, the handing over of the land was done on 19th April 2025, my lord.
Draft award 1 of 24
Yes, my lord.
has been approved on 27th of March
2024.
24.
Yes, my lord.
Handing over on 19/4/25.
Yes, my lord.
Then now what is there remaining?
And with regards to your lordship's other query of, with regards to section 51, 52, and 53 of the 2013 Act, my lord, if your lordship will allow me to produce a notification dated 19 December 2025, my lord.
What does it say?
This is with regards to the appointing the existing courts and district courts as the LARR authority and presiding officers, my lord.
Okay. So now, who will pay the compensation?
It's to be paid by the union, my lord, central government.
Yes, has it been communicated to them?
It has already been paid, my lord.
Paid?
Yes, my lord.
My lord, paid as per the draft award. My lord, what is required to be done? My lord, there is no concept of draft award in the 2013 Act. Section 23 says about award, my lord.
Mr. Nair, you have been paid the compensation.
As per the draft.
Not at the rate you
Yes, my lord.
expected.
Yes, my lord.
So
Yes.
now, you invoke
We have to
51.
go to the authority.
Invoke
Yes, my
51.
lord. That is what I wanted to know, my lord, whether this authority had been considered, because this was not published.
Now you know you will
Now,
close this
yes,
matter
my
with liberty.
My lord, there is another aspect. My lord, we can approach against the award, but the draft award, my lord, whether that has been pronounced, that has not been pronounced is my instruction. Whether that has been finalized or not. But if that is the same award which they make, which they construe to be the award, then we have to go against that to the authority. However, my lord, it is to be we can approach the authority only against the award, not the draft.
No, draft award, that naming is always, it's a misnomer.
Yes, my lord.
You must be aware about that.
My lord, my lord.
It goes from this year to that year. It remains a draft award, but it's approved, paid, everything and all that.
My lord. My lord,
They
in-
don't take out the draft part.
My lord. My lord, if they say it is the award, then we have to go against that. Because, my lord, in the other case, today, item number 5, that there was similar, there was a draft award, and against the draft award, it was pronounced as an award. That document I had, it is annexed to item number 5. So that is why the confusion, my lord.
Item number 5 is similar?
My lord, that is in respect to the Aizol helipad,
Okay,
the Twampui helipad.
okay. This is item 1, 2, isn't it?
Item 2, my lord.
Oh.
This is the Lungle, my lord, the Pukpui IAF.
So we'll close it, Mr. Nair?
My lord, with liberty, my lord. To
Yes, definitely. Heard Mr. P.D. Nair, Learned Counsel for the Petitioners, and Mr. Samuel Vanashi at the Sangte, Learned Additional Advocate General. Stop. The Learned Additional AG was asked to inform the court as to whether no, you're right, like this. On 16/3/2026, court passed the following order. Please abstract this. Next para. Today, Mr. Samuel Bangladesh Dachangte, Learned Additional AG, submits that the draft award number 1 of 2024 was approved by the state government on 27/3/2024. And that the land has been handed over to the Respondent Union of India on 19/4/2025. For whose benefit the land was acquired. Stop. Insofar as compliance of Section 51 of the Act of 2013, Learned Additional AG submits that a notification has been issued by the Government of Mizoram in the Land Revenue and Settlement Department on 19/12/2025 in exercise of the powers conferred by Section 51, read with Section 52 and 53 of the Act of 2013, by appointing the existing courts and district and sessions additional district and sessions judges as the land acquisition, rehabilitation and resettlement authority and presiding officers within their jurisdiction for speedy disposal of disputes relating to land acquisition, compensation, rehabilitation and resettlement for land acquired in the state under the Act of 2013 with immediate effect. Next para, considering the above position and the grievance projected by the petitioners, the petitioners would be required to avail the remedy available under section 51 of the Act of 2013. Stop. Mr. P.D. Nair, learned counsel for the petitioner, submits that liberty may be granted to the petitioners to approach the competent forum. So in view of above, the writ petition stands disposed of with liberty to the petitioners to approach the authority constituted under section 51 of the Act of 2013. One more line, Ms. Xylem Sangpil under CGC appears for the respondent Union of India. You want to submit anything?
They have to oppose the appropriate from the state in
Okay.
the section 64, 2013.
Under section
64.
64. Appears for the respondent Union of India and submits that with the relief sought for by the petitioners, they are required to approach the competent forum under section 64 of the Act of 2013. You put that somewhere in the beginning part.
My lord, Lordship had dictated on this, we have to approach under section 51. This is to be 64.
Correct, 64. 65.
My lord,
61 is the appointment.
My lord, any delay, my lord, that aspect.
What? That how will I deal with that? It
My
will be
lord,
difficult.
Section 14 of the Limitation Act would apply, my lord.
You impress upon the
My lord, my lord. Deeply impressed.
one more line, the notification dated 19/12/2025, produced by Mr. Samuel Bounce, the Changtel London Additional AG, is being retained in the record and marked as expired. Mr. Nair,
My lord.
you have some other matters also.
Yes, my lord. Item 5, my lord.
Today is your exit?
Tomorrow, my lord.
Tomorrow?
Tomorrow.
Then you can wait.
My lord.
All right, we'll
my
come
lord.
back.
My lord. My lord. Deeply impressed. Lord, I apologize for the intrusion. I apologize for the intrusion, my lord.
Yes.
I've been given to understand that in item number 3, some time will be required. My lord, mine is item number 4. My lord, some affidavits had been filed both by the state and the union. My lord, I'll need some instructions. Could that be on
Item
some-
4.
Item 4. Sorry. I need some instructions and file an affidavit if required.
Call item 4.
Item 4.
How much time you require?
My lord, the other matter, yesterday's matter was fixed on 15th of May. But could it also be on 15th of May, my lord?
Affidavits have been filed?
Yes, my lord, both by union and the state.
Mr. P.D. Nair, learned counsel for the petitioners, submits that he needs some time to obtain instructions from his clients and prays for adjournment. In view of above and as prayed for, list again on
15th of May, my lord.
15th of May.
My lord. Deeply.
Item 3.
Lordship, in this writ petition, we have come against the orders passed by the Learned Lower Court in connection with the eviction suit number 4 of 2019, as well as execution case number 52 of 2020, and also CMA number 1194 of 2025. And Lordship, the facts of the case, in brief, is that the petitioners are landless inhabitants of plot of land, which is lying on the side of the road near that Ebenezer Hospital. They have been earning their livelihoods by chipping stones and selling them for the purpose of construction. They are just staying there, and in a tent, they used to be there. And that was sometime in the year 2012. And thereafter, in 2014, they had applied for allotment of the sites where they were occupying. And there was a recommendation for allotment of the site, for house site also, in their favor. And that was also recommended by the authorities at that point of time. And while they were staying there, Lordship, there was a process for allotment of house site passes to those petitioners, along with one other member who is no longer a petitioner here. And in the meantime, Lordship, there was an application in that, may I take a Lordship to Annexure 1 at page 23.
See, Mr. Ramzao, you filed a writ petition against which order? Some eviction order.
Yes,
Where is the order?
the order is
Page 74.
at page 74.
This is the impugn order.
Yes, Your Lordship.
And who
74.
are the parties here?
74 here, the petitioners, the parties are, the plaintiff is C. Zarzoliana, who is now rated as respondent number 5 in the instant writ petition.
No, are you a party in this case?
Yes,
The eviction suit.
Ngur Dailova, yes, Ngur Dailova, Vandal Liana, and Lalrim Liana. These are the
Okay.
the petitioners. So the order which was passed in connection with this eviction suit is dated 26 to 2020. Lordship,
It was an ex parte order.
It was an ex parte order, and all the issues were decided against us. And for carrying out the said order and decree, Lordship,
But why have you invoked writ petition? Article
Lordship,
226.
yes,
Writ
that's
jurisdiction.
one question that needs to be answered before entering into all the merits, Your Lordship. Because the order has been obtained by playing fraud upon the Honorable Court and against the the writ petitioners. And when there is fraud,
How is that?
Lordship, there is suppression of material fact. By suppressing the material fact, they have, the respondent number 5 have claimed that the land where the petitioners are residing belonged to him. In fact, it was earlier within the land of the respondent number 5. It was within the land of the respondent number 5, which, however, was subsequently acquired by the state. A portion of his land was acquired along the road. And that was for the purpose of widening of the road. And
The land of respondent number 5 was acquired.
5 was acquired, some part of it.
Okay.
And that portion of land which has been acquired for the purpose of widening has not been utilized for that purpose. And it has been under occupation of the petitioners. It is now under the control of the PWD. And
On what basis have you been occupying the land?
I have been occupying just with no order and without any authority. We were landless, and we have no place to stay. We were just depending upon the earnings made by us by cracking stones and selling them for purpose of construction.
But is there any space there for having a land, putting up a house or something like that?
It is there. Your Lordship, the report of the PWD has clearly mentioned.
So you have filed the eviction suit.
They have filed the eviction suit.
On what they have filed.
They have filed.
The respondent
They
number
have-
5. On
yes.
what basis?
On the basis that
On the strength
land-
of his LSC,
yes, on the strength of his LSC,
which was already acquired.
portion of which was already acquired. He is still having the LSC, but it has been modified after acquisition. That modified portion, that remaining portion after the modification of his LSC after acquisition, did not include the land where the petitioners are staying.
I see. So the respondent number 5 has a land.
Yes,
Some portion was acquired. After acquisition, LSC was modified.
modified.
It was reduced perhaps.
Yes, reduced.
Then on the land which was acquired, which was lying vacant,
yes,
that portion you have acquired. You have occupied that
Occupied,
land,
yes.
area.
and in
But
fact,
by merely occupying, what right does it give you?
that's true. We have no right as such, but we had made application for allotment of site from the authorities of the Revenue Department.
And any response?
There was a response, positive response is there. And here at page 23, Lordship, there is a letter addressed to the Director of Land Revenue Settlement. Translated copy is at page 25. It's a letter from one minister addressed to the Director of Land Revenue Settlement, where it is stated, the 4 persons from Chonpui, namely Lallian Thanga, Larem Liana, Vanalian and Ngudailava, who earn their livelihood by chipping stones daily, are actually homeless. The land they have requested for allotment as house site should be duly verified to see whether it is vacant and available for allotment. If it is found to be vacant, kindly initiate the process for allotment. There's a note, they are individuals who build temporary houses in Chonpui Veng near Tuikwal Bridge on PWD road site, who earn their livelihood by chipping stone. Matters should be referred to the PWD. They are in a pitiable condition. They may be given all available assistance. And that letter was written by one Mr. Lalthanzara of Zarkot, who was at that point of time Minister of State. And thereafter, Your Lordship, at page 26, there's a letter addressed to the Chief Engineer, Building, from the Assistant Settlement Officer for the Director of Land Revenue Settlement. In that, it is on the subject of house site application at Chonpui. With reference to the subject cited above, I have the honor to state that Lallian Thanga and 3 others have applied house site at Chonpui near to equal lay, which are existing at applied sites. The marketing surveyor does not know whether the applied site fall within PWD road reserve area or not. Therefore, you are requested to clarify whether the applied sites fall within road reserve area or not. Hence, house site applications in respect of Lallian Thang and 3 others with all connected papers are also sent herewith for further action and resubmission after completing the required formalities. At page 27, Your Lordship will see the comment of the Village Council and the report of the demarcating surveyor. It's translated at page 28, para 18 and 19. The house site that Sri Ngur Dailava applied for is known to be free of vacant land. He had constructed his house where he is currently residing. This is the recommendation of the Executive Councillor, AMC Aizol. And report of the marketing surveyor is, according to AMC, the land in question is free land designated for house sites. And there was a sketch map prepared by the surveyor, and it was properly surveyed. This is in respect of Ngur Dailava, and the one at page 30 is in respect of Vanlal Liana, more or less the same thing. And at page 33 is Nalrem Liana, and at page 34, it is stated, Nalrem Liana, the applicant is not having any house site land. The site applied for by him is known to be free or vacant. That is Nalzir Liana, MC Councillor. And the applicant has constructed a temporary house building on the site applied for by him where he is currently residing. That is the report of the marketing surveyor. All these have been furnished to the PWD.
3 persons.
3 persons.
But the name given by the minister concerned was 4 persons.
4 persons, because
Lallian Thanga.
there is one person who is on the site, but that person, there is no complaint against him. So he has not come before Your Lordship.
Lallian Thanga.
Lallian Thanga.
Okay.
And accordingly, the matter was verified. And here at page 36, Your Lordship will see the superintending engineer, PWD Building Circle, home site, applicant at Chonpui near to Equal Bridge. I have the honor to submit here with no objection for allotment of house site for the following persons if they are allotted 4 or 3 meter for site drain, edge upper site. I therefore request you to kindly to pursue the matter from the higher authority to issue no objection certificate. This is from the executive engineer addressed to the superintending engineer. And here the superintending engineer had informed the chief engineer by letter dated 16 September 2014 on the same subject, house site application at Chonpui. With reference above, I have the honor to submit here with the following points for favor of your kind information and taking further necessary action from your end as follows. The average existing road width of blacktopping is 6 meters, such that there is side drain of width 0.40 meter between the existing road and the proposed house site in the uphill side. However, if the road is to be upgraded to intermediate lane standard, additional land of 4 meters towards the proposed house sites will be required, so that the total width of the road will become 10.4 meters. And the remaining land beyond the requirement of intermediate lane may be recommended for LSC. A sketch map is also enclosed here at page 38. Your Lordship, these are the 4 persons, Ngur Dailava, Vanal Liani, Lalram Liani, and Lalian Thanga. Lalian Thanga is not a party here. These three persons have approached this Honorable Court. Your Lordship,
This is towards the uphill side,
towards the uphill side,
not towards the stream.
not towards the stream.
I see.
The uphill side was
Uphill
earlier
side?
the land of the respondent number 5.
These 5 individuals are
4
residing,
individual. Yes, 4 individual.
residing temporarily
Yes, temporarily.
in those areas.
Yes,
And they applied for house pass.
yes, yes. Your Lordship.
And what about respondent number 5? Where is he?
Respondent number 5, he is not having, his residence over here. He was allotted a land, and the portion of it has been sliced out for the purpose of this road widening. And the land, the place where the petitioners have been residing is that portion which has been
Sliced out.
Sliced out. So it is.
So that means
it is no longer
His
the
land is above. His land is above this land.
Yes,
These
yes,
houses.
Yes.
Okay. He may not be residing there, but he still has a land there.
Yes, yes, he's still having a land. It is contiguous.
But this has been sliced out from his land.
Yes, yes, that's true.
So you are saying that since it's already sliced out, since it is already sliced out, he cannot have any say now.
He cannot have any say.
Since it has not been utilized,
Yes.
it was sliced out for what purpose?
It was sliced out for the purpose of road widening.
Widening. So after all,
because-
widening is not required now, or what?
Road widening has not been implemented as per the earlier proposal. Now it remains unutilized for the purpose for which it was acquired. So taking advantage of that, the petitioners have been just staying there, having their temporary huts and accumulating whatever stone crust which they have to sell to the needy persons for purpose of construction. And here, Your Lordship, the matter has been taken even up to the engineer-in-chief. Engineer-in-chief was informed by the Deputy Director, Administration, Chief Engineer, PWD Building, via his letter dated 22nd September 2014. Because why all this matter has been dealt with by the PWD is that it was the PWD that had acquired the land for the purpose of road widening. Now, whether they still need it or not, and whether they are having any objection to allotment of the house site to those persons is to be decided by the PWD, because it has been referred to them by the revenue authorities. Revenue authorities said that since we do not know whether the lands being occupied by the petitioners would fall within the PWD road and whether it would be required by the PWD. So the matter, after being examined, it has been stated here at page 39 in Lordship, if I may read again. The average existing road width of blacktop is 6 meters, and there is side drain of width 0.40 meter between the existing road and the proposed house site in the uphill side. Besides, if the road is to be upgraded to intermediate lane standard, additional land of 4 meters towards the proposed house site will be required, and the total width of the road will become 10.4 meters. And the remaining land beyond the requirement of intermediate lane may be recommended for LSC as sketch map enclosed herewith for ready reference and further necessary action. Original document sketch map that has been enclosed in the letter. And the matter was sent back to the Director of Land Revenue and Settlement at page 41, Annex 6, Your Lordship, by the Deputy Director, PWD, Engineer-in-Chief's Office. Here, it has been informed. With reference to the above, I have the honor to send herewith clarification received from Chief Engineer, PWD Building regarding house site applied in respect of Lal Liantanga and 3 others, whether their applied sites fall within PWD road reserve area or not, along with its enclosures for further necessary action. So he has enclosed all the reports and the no objection made by the PWD and the matter was given back to the Director, Land Revenue and Settlement, for the purpose of allotment of sites. That was way back in the year 2014. Lordship, at this stage, as already stated, there was a land acquisition process which was conducted and finalized as per the draft award number 3 of 2002. And in that, the name of the petitioner, the respondent number 5, is at serial number 15
Yes.
at page 43.
He has received 2,03,364.
Yes.
I've seen it.
And
how much area has been taken away from him?
it is 4067.28 square meters.
Square meters.
Yes.
And the total area which you have, three petitioners claim is how much?
Lordship, as per the well, if I might take Lordship back to the sketch maps, it is 225 square meter. That is for one.
225. Page number?
Page number 32.
$225 square meters.
Hmm.
And 4067 is square feet.
Yes.
But where's the beginning of page 44? It starts with serial number 7.
Page 44.
Yes. Serial number 1 to 6 is missing. It starts from serial number 7. There must be one more page.
43, 44. Lordship, market value, that is there. Page at the bottom of page 43. Market value under para 4.
Oh, I think you have put the pagination, page 46.
46, that is Solatium.
46 comes before 44, 43, I think. I mean, 46 comes before 44.
Some misplacement of the pages.
Yes, yes. Anyway, so 46 comes before 44. Because serial number 1 to 6 is there at page 46.
Yes.
So continuation is at page 44.
Continuation, yes, page 44.
So you mean to say, as per this award, they have been paid already?
The respondent number
paid?
5 has already been paid, and his land has been modified. A portion of his land was sliced out, and thereafter he was issued the modified LSC.
Page 51.
Page 51.
Any indication there about the modification? Earlier it was how much, and now it has become how much? 428.28 square meters. So earlier it would have been 428.88 square meters plus this 4067.28 square feet, probably. So how did this eviction suit come about?
Yes, Your Lordship. Thereafter, the petitioner, the respondent number 5 had submitted a complaint at page 58, Your Lordship.
59 is the translation.
Yes, 59 is a translation. And where he had stated that his land has been occupied, illegally occupied by the petitioners, Murdailava, Vanal Liana, and Lalrem Liana. These are the 3 persons who approached this Honorable Court. Location of the above-mentioned landed property at Chon Pui Veng, Aizawl, is at New Kapil Complex, Chon Pui Veng Road, near to Equal Bridge. So, pursuant to the the complaint submitted by him, the so-cause notice was issued, Your Lordship. The translated copy is at page 61, the so-cause notice. May I read, Lordship?
Yes.
Sri Dr. Cesar Zoliana, son of Pachung Changte, owns a landed property registered under LSC SZL number 3194 of 1985, in which 3 persons, namely Ngurdailova Vanalian and Larem Liana, all of Chon Pui Veng, are known to have constructed their house after conducting spot verification. According to the said spot verification report, it is found that Zarzoliana is having LSC number 3194 of 1985 over the land in question. It is found that Sri Ngurdailava, Vanalian and Laremlian had constructed their house over the land in question. It is found that the said 3 persons do not have proper house pass. However, it's found that following the application for issuance of house pass, Lal Soimo, a surveyor, had done measurement for construction of their house. Pass have not been issued. As stated above, since Ngurdailava, Vanali and Laremliana, without any proper house pass or LSC, have encroached upon the private property and have constructed their house without the approval and permission of the rightful owner, there is no way for them to claim any right of ownership over the said landed property. However, if they have any grievance regarding the eviction from the said land, they are informed to submit their application to the District Revenue Office on or before 27/2016. Your Lordship, here the finding of the spot verification as shown in the so-cause notice is a little bit faulty, in the sense that it is found that Zarzoliana is having LSC number 3194 of 1985 over the land in question. That is a thing of the past. LSC number 3194 was before slicing out that portion, before the acquisition. After acquisition, it was no longer 3194 of 1985. It was LSC AZL number 3194 of 1985. That creates a difference.
Same number.
Same number, but AZL, after acquisition and modification, AZL was added.
AZL means Aizawl, that's all.
That's all.
What is there?
But the area was different. The area of
course,
the original
area-
pass under LSC number 3194 is different from the area of the modified LSC under AZL number 3194 of 1985.
Okay.
So this is
So,
one thing.
Complaint was submitted to the revenue.
Yes.
They issue some show cause, some verification was done.
Yes.
Any verification was done?
Verification was done, and we were also called upon to submit a
What is
reply.
what is the verification report?
Here at page 84, no, 64, Lordship, so-cause notice was again issued.
No, that I've seen already. Where is the verification report? Anything?
Before that, the Lordship, at page 66, the reply of the petitioners.
That also I've read.
Yes.
That you have said your application is pending. We are under the impression that
Yes, yes.
will be given. It is a PWD land, all that.
Yes.
But any separate verification done?
There was no a proper finding of the verification report, and in spite of the reply that we have given, the respondent number 5 had approached the Senior Civil Judge Court
For eviction.
for eviction. And
So
that eviction was
eviction has been
conducted
based on what?
on the basis of, Your Lordship will see,
Or on the basis of his LSC?
LSC.
But you failed to appear before that.
We failed to appear.
Why?
Because we had engaged one counsel whom we have entrusted to conduct a case, but he did not appear. That we did not know. He did not inform us also. And finally, the matter was decided in our absence.
He was engaged, he did not know.
He was engaged by us, and
And he did not know that
he did not appear.
he did not appear.
He did not appear. And he did not inform us anything about the outcome of the proceeding also.
He did not appear on the date of the hearing, or he did not appear at all, once also.
From the order that was passed, Your Lordship, it appears that,
Multiple occasions.
yes, on multiple occasions, he did not appear. And no WS was also filed by us, because we are not intimated as to what steps should be taken by us, because the kind of litigation which we had faced in connection with the eviction suit, that was something beyond our comprehension. And the counsel whom we have entrusted also did not make any such appearance on our behalf.
Okay, Mr. Ramzawal, there seems to be no affidavit filed till now. We asked the Revenue Department what they have done. They are a party? Who is the counsel? Government advocates?
My lord, if I may just make a short submission here, page 76.
Yes, what is that?
Page 76, the middle paragraph. That's the order, the eviction suit, final order in the eviction suit. The respondents number 1, 2, and 3 appeared in person in this court on 17/10/2019 and are directed to avail the service of legal aid counsel. The respondent number 1, 2, and 3 have, however, failed to appear before the court on any subsequent court dates, in person or through a counsel, despite beside notice being issued and having been clearly informed to do so in person.
All right.
The suit was then proceeded with ex parte, and issues were framed on 12/2020. The counsel for the plaintiff also submitted his examination in chief, and since no one appeared for the respondents 1, 2, and 3, no cross examination was conducted. So that they willingly did not participate in the process, and now they're bringing up new materials, which they should have brought up at that time, my lord.
All right.
Also, my lord, this is an appeal filed in the disguise of a writ petition, my lord. They've already filed an RFA in this court, RFA number 27/2025, which has been dismissed.
Dismissed.
Yes, my lord, by this.
You have a copy of the order?
It is here.
Meanwhile, Mr. Samuel, why didn't you file affidavit in this writ petition? Awaited. Because there's some process was undertaken. The complaint came to you, Revenue Department. Some show cause notice, something was there. So ultimately, what have you done that we would like to know?
On the 9th of March, advised to make a consolidated evaluation.
Okay.
So we're waiting for that.
Waiting for that, okay. IA. Now we have to know what is IA.
In connection with that, Your Lordship, the order that has been passed by the,
Unless you tell me what is the IA, how do I understand this?
For duration of 1,800 or so days.
The delay was not condoned. And so it was dismissed. And in view of non-condition of delay, the appeal also gets dismissed. And now they file a writ petition. What was the subject matter of challenge there? The eviction suit only.
Yes.
Eviction order.
Going on at the same time. So they challenged that
Now what is challenged here is the execution.
as well as the eviction.
Eviction. Where's the execution order? Any order here?
subsequent to this order. the
Oh, this
order that
IA is available here in the, no, this is what, 112? Oh, sorry. Okay, yes, 112, page 92, annexure 19 is the order passed in the delay condonation application.
Yes. The link case is RFA 27/2025.
You are challenging both the eviction as well as the execution, or what?
Mainly the eviction. After that, after this dismissal of or rejection of the condemnation application, the order was passed in connection with the execution case at page 102, Your Lordship.
So on what grounds are you challenging these two orders? Especially after you have availed for that RFA, which was rejected.
Yes. Lordship, what I mean, we have stated here in this writ petition is that since all doors have been closed, there's no remedy, because what we have done for the purpose of condonation of delay, that was also rejected. Now, there's no other remedy.
Remedy
that is
lies,
available.
but elsewhere, not here.
Yes. And here,
You cannot,
Your Lordship,
you cannot convert this court into a Supreme Court.
Your Lordship, I have taken the aid of the law laid down by the Supreme Court in some few cases. Your Lordship, if I may take Lordship to 2007 for SCC 221.
No, why do you say fraud?
Yes, fraud because there's misrepresentation during the course of eviction shoots, because it has not been highlighted that the land where we are residing is no longer the land belonging to the plaintiff.
So point out that before we go to the judgment,
Right.
where in the judgment of the eviction suit or on the, what do you call, the execution, is it mentioned that this is the land of the respondent number 5? So you have no right.
In the writ petition,
Page 77, ma'am.
in the writ petition, at page 16, paragraph 24. Paragraph 24.
Page?
Page 16. Page 16 of the writ petition.
No, no, I'm talking about the judgment, the finding of the land trial court that this is not your land, but the land of the respondent number 5.
77, ma'am.
Issue number 5.
Issue number 5, yes, ma'am.
70, starting from 74. Five issues were there. At page 75, Your Lordship, the 5 issues which were framed by the trial court: whether the present suit is maintainable in its present form and style, whether the plaintiff is entitled to relief claim, if so, to what extent, whether respondent number 1 to 3 have illegally built houses and are illegally occupying the land of the plaintiff covered by LSC number SZL 3194 of 1985, located at Sonpur Aizol, whether respondent number 1 to 3 have any land passes in respect of the lands they are currently occupying, where respondent number 1 to 3 are liable to be evicted from the land of the plaintiff covered by LSC number SZL 3194 of 1985, located at Sonpur Aizol. Counsel for the plaintiff submitted examination in civil plaintiff on 17/2/2020, and the suit had been proceeded with ex parte. No cross-examination was conducted, as the respondents were not represented in the court again.
Okay, just pause there for a moment. You had made one director or land revenue party also, pro forma respondent perhaps? Any WS?
No, my lord, they were former respondents, but they did not submit any.
No WS.
No WS, ma'am. No evidence whatsoever.
Should I read the findings, the decision of the,
Mr. Ramzao, I have read it. Issue number 5, we come straight to that at page 77.
whether the respondent number 1 to 3 are liable to be evicted from the land of the plaintiff covered by LSC number so-and-so, located at Chonpui, Aizawl. Respondent number 1 to 3 has failed to submit any legitimate claims to explain the occupation of the plaintiff's land covered by LSC number SZL so-and-so. With regard to the observations made in this suit, respondent number 1 to 3 are liable to be evicted from the land of the plaintiff they are occupying. This issue is also decided in favor of the plaintiff. In consideration of the above, it is hereby directed that respondent 1, 2, and 3 to immediately vacate and leave the plaintiff's land covered by LSC numbers and so located at Chonpui, Aizawl within a period of 3 months from the date of this order. Also directed that respondent 1, 2, 3 to remove or demolish all the structure at the plaintiff's land covered by LSC number and so located at Chonpui, Aizawl, and the plaintiff shall not be liable over any remaining properties or structures in the land of the plaintiff.
Mr. Ramzawa, we'll do one thing, we'll adjourn this matter. Let them file an affidavit.
Not,
From what appears, there's no finding to the effect that this is the land of the respondent number 5. It just says that he has got LSC, you don't have LSC.
that's all.
So you are occupying on the basis of no document. So you are liable to evict it. That is the finding.
Yes,
There
yes.
was no finding that this LSC, the land which you occupied is within that land. So what the revenue department has done, let us have a look at that.
Yes,
And that is prima facie what we are understanding. Of other aspects are also there, no doubt. Whether we can go by the writ petition will be maintainable or not, all those aspects. And definitely you would like to point out this fraud thing.
yes.
So let us see. We'll give them some time.
The only allegation made right now is fraud, which needs to be proved by evidence, my lord. And that ship has already sailed. We're just prolonging justice, my lord. And we are continually suffering from 2020, since when the eviction suit was filed. They don't have any documents. And
They cannot be said to suffer anything because it is not their land.
Anyway.
LSC has also never been challenged at any stage. And their application for house passes has also not been processed by them or.
We're not challenging the LSC
No,
because it
that's
was
why-
modified.
Let us find out, let us see what the revenue has to say, because you have made them as a pro forma only, so they didn't want to say anything in WS, and it's gone ex parte. And, but they must have done something about it. Let's see.
And also, my lord, this court doesn't have the jurisdiction to modify the orders of a subordinate court under 2227, my lord. I have a judgment to.
Right, you save your submissions, Mr. Rustam Gawla. Since we are not deciding the matter right now, okay? Definitely, you keep it ready, so that next time or whenever the counter is filed, we can look into all these aspects and take a call. Upon considering before that, you write, parties are represented by the respective counsels. So upon having regard to the issue involved, a response from the Land Revenue and Settlement Department would be necessary for effective adjudication of the matter. As prayed for by Mr. Samuel Valarhetik Sangte, learned additional AG, further 3 weeks' time is granted to file counter affidavit. List again on so and so.
And in the meantime, Your Lordship, let the stay continue.
There's a stay.
Yes. In connection
Stay
with
in which, by which order?
because the order which was passed for demolition of the buildings, the structures,
Execution.
No, stay is passed in which, in IA?
in connection with 227, yes, 227 of 2025.
Okay, list again on today's what? Today's 17, isn't it? 1,
Today 17.
3. List again on 20th of April, 20. Interim order passed earlier shall continue to the next date of listing. Let us close this IA. What is the requirement? Because again, you'll get confused later on. In the IA 227, you write? in view of the interim order being continued in the main writ petition, the IS stands closed.
Yeah, please.
Item 5.
Caveat has been discharged. Then you write caveat discharged, okay? Caveat is also discharged. Item number 5.
Yes, Your Lordship, I'm representing the state government, respondent number 3 to 5. And I'm seeking another 2 weeks' time to file my affidavit in opposition.
Similar prayer for respondent number 1 and 2.
We have received affidavit from the respondent number 7.
That is the NHRDCL.
Yes.
What do you say? What did you say in your affidavit? You want your land to be acquired under the National Highways Act. There is no compensation given to you, Mr. Ramjawa.
Compensation has been given to us, but the thing is that the manner in which it was decided and assessment was made was not proper. There has to be interest. Interest was also not given to us for the period in between the notice and the award.
So in the acquisition under the National Highways Act,
Yes.
the Act of 2013 also will
Yes.
be applied.
Yes.
And who are the parties concerned here? Assessment has been done by whom?
Kala, my lord,
By
competent authority.
the
Kala.
additional DC.
Anyone appearing for Kala? Number 6.
None has appeared, my lord, entered appearance.
Who appears for Kala?
They appoint their counsels independently, my lord.
No, who has entered appearance?
No one, my lord.
No one so far.
Then what about the notice? Is it complete? AD card returned from respondent number 6 after duly signed, kept in court file, correspondence file. Respondent, competent authority. Lal Choi Lavi, signed by Lal Choi Lavi.
Must be the PA.
Please write, parties are represented by the respective councils, except for respondent number 6. So what, office note dated 15/1/2026 indicates that AD card has returned back from respondent number 6. So upon perusal of the AD card, it is seen that one Srimati Lal Choilavi, spelling LALCHUAILOVI, has given her signature in the column meant for signature of addressee. And the date of delivery is shown as 15/10/2025. Considering the same, notice is accepted to be complete upon respondent number 6. Stop. However, as no one appears for respondent number 6 today, necessary orders will be passed in due course. Next para, Mr. Samuel Balrashid Sankte, learned standing counsel, NHRDCL, appearing for respondent number 7, submits that counter affidavit has already been filed by respondent number 7. Ms. Zarem Sangpui, learned CGC, appearing for the respondent 1 and 2, and Ms. Vanesiami, learned government advocate, appearing for respondent number
2 and 2, 4, 5.
2, 4, and 5. Pray for further.
3 to 5.
Respondent number 3 to 5. Praise and are granted for the 3 weeks' time. to obtain instructions and to file counter affidavit. List again after 3 weeks. Well done.
Item 6.
Lordship, this is the matter regarding claim of compensation by the husband of the deceased, Yang Niangi, who was killed by wildlife elephants inside Ngengpui Wildlife Sanctuary.
Okay. Any such kind of ex-gratia or something like that to be given?
As per the state scheme, which is at page 34, it's a notification
Your
dated
Lordship,
7 May 2014.
Your Lordship,
It
if I
is
may,
there.
we have received the Paraguay's comment and we will be filing our affidavit within 2 weeks, Your Lordship.
What is there in the Paris comments? Any idea?
Actually, Your Lordship, in this matter, Ms. Lalnunlu is handling the case, so I don't know
Okay.
the matters.
Okay. Anyway, let us see. As per the notification under the Wildlife Protection Act,
Yes.
there's some sort of a scheme.
Scheme is there, yes.
Ex-gratia relief. Damage caused by wildlife. To
In case
himself
of injury to human beings,
or to his family members or dependent. or his
yes,
own
in case of death of human beings,
2 lakhs.
the 2 lakhs only. Whereas, Lordship, at page 37, the central government, during the discussion in the Lok Sabha, star question was answered by the concerned minister at page 37, at para 5. Centrally sponsored scheme, development of wildlife habitats and Project Tiger Elephant also provides for payment of ex-gratia relief to the victims of human wildlife conflicts. Ministry has enhanced the amount of ex-gratia relief in case of death or permanent incapacitation due to wild animal attacks in December 2023 from 5 lakhs to 10 lakhs under these schemes, subject to availability of funds and the payment of which is also governed by state-specific guidelines, provisions made in this regard.
This subject to part has curtailed your rights
Yes,
to some extent.
yes. In spite of this, Lordship, we have impugned the provision of this notification dated 7 May 2014.
Oh, you have impugned this also?
Yes, yes. Because the life of the people of Mizoram has been put to
Okay,
the
then
value
in
of
that case,
2 lakhs only, while in the central government it is up to 10 lakhs.
So let them answer them.
Yes.
Let them file their affidavit. Please write, by filing this writ petition, the petitioner has not only claimed ex-gratia payment of compensation on account of the death of, who's the claimant? Husband
Husband,
of his wife on being trampled by a wild elephant.
yes.
But the petitioner has also challenged the notification dated 7/5/2014, bracket Annex 11, by which the ex-gratia payment has been limited only to rupees 2 lakhs. Whereas the ministry, which ministry is this?
Ministry of
Ministry of Ministry.
Environment. Let me. Environment, Forest and Climate Change.
Ministry of Environment, Forest Environment. What is first? Ministry
Environment. Environment, Forest and Climate Change.
Ministry of Environment, Forest and Climate Change has taken a decision to enhance the ex-gratia payment from rupees 5 lakhs to rupees 10 lakhs, which is not so in the case of the state. Ms. Vanessiami, learned government advocate appearing for the state respondent, submits that she has received the para-voice comments and prays for 2 weeks' time to file counter affidavit. Anything from CGC? You're not a party? Okay. Your notification, okay, anyway. Yes, prayed for, 2 weeks' time is granted. To file counter affidavit, list again after 2 weeks.
Obliged.
Yeah, please.
Item 7.
My lord, I am for respondent number 1 to 4. I may be given 3 weeks' time for filing my affidavit in operation.
Your Lordship, I'm representing the respondent 5 and 6. And similar prayer, Your Lordship, to file the affidavit in opposition.
5 and 6.
Yes, Your Lordship.
And remaining is Ms. Zarem Sangkui.
I am 1 to 4.
Who else are there? And, you appear for 1 to 4. Ms. Zarem Sangkui?
Yes, my lord.
Okay, what case is this? What kind of case is this?
Lordship,
Financial assistance.
yes, my lord.
Would repatriated to Mizoram prior to signing of the accord. Okay. All right. Parties are represented by the respective councils. Stop as paid for by Ms. Zarem Sangkui, learned CGC, appearing for respondent numbers 1 to 4, and Ms. Vanessiami, learned government advocate, appearing for respondent numbers 5 and 6. Further 3 weeks' time is granted for filing counter affidavit. List again after 3 weeks.
Obliged.
Item 12 for hearing.
Yes.
Yes, may it please your lordship. My lord, this is an appeal against an impugned judgment and order that had been passed in eviction suit. And I was the defendant in the eviction suit. And after filing my written statement, a preliminary hearing was conducted, wherein the trial court has directed the Land Revenue and Settlement Department to conduct a spot verification. And when the surveyor has conducted a spot verification, he has submitted the report before the trial court. And then he had submitted that spot verification on 7 June 2024. And just after 1 month of submission of that spot verification report,
7 June?
7 June 2024.
Is it annexed here?
No, my lord. But however, it is reflected in the judgment and order.
I see.
Yes.
This is surveyor's report.
Yes, yes, my lord. And only after 1 month, that is on 25th of July 2024, the learned trial court has passed a judgment and order stating, without giving an opportunity to object this spot verification report, or without giving an opportunity to examine the maker of the spot verification report, I was directed to vacate the land of the land which is registered as LSC 37 of 1978. LSC 37 of 1978, which was registered by the name of S. Tansanga. I was directed to vacate that land within 3 months from that order. Now, my lord. Yes.
You are a relation to S. Tansanga?
No, my lord. I have LSC of my own. My LSC number is 332 of 2008. But there is some history with the father of the respondent. This S. Tansang is father of the respondent. Actually,
you have a separate LSC?
Yes, separate LSC. That is LSC number 332 of 2008.
I see. Then.
Yes. Now, my lord, if
you are all this LSC and 332 and 37, they are side by side or overlapping.
That I cannot say, my lord, because I know that I have a registered LSC. That is in my name. Before, it was in the name of Tansanga. However, this LSC 332 of 2008 was later registered in my name. My lord, if I may take your lordship to page number 63. 63 of my appeal petition.
Yes, 63.
Yes, 63. That is the certificate of land settlement. First, it was recorded as Tansanga, the owner of the property. However, later it was struck off and it is written as Arlel Thanpari. At the bottom also, in a seal, it is written transfer to Arlel Thanpari. So according to me, I am the registered owner and the rightful owner of this LLC.
How you became the owner?
So now, my lord, I have to enlighten your lordship with the brief facts of the case.
Surely.
Yes. First, there are two brief facts of the case because my learned friend has his own contention. I have my own contention. So one is the contention as projected by the respondent, and one is the true and correct fact of the case. Now, first, I would like to enlighten your lordship on the brief facts of the case as projected by the respondent, who is a plaintiff in the eviction suit. It is that there was a rent agreement between this S. Tansanga and one Arlel Mingliana. Now, this Arlel Mingliana is my brother-in-law. Now, if I may take your lordship to page 48 of my appeal petition, that is the rent agreement. 48.
48.
Yes. That is in Mizo vernacular, and in the next page, 48A, that is a true English translation. As if, with your lordship permission, if I may read out.
Yes.
I, as Tansang of Saipum, is unable to continue the construction of the building located at Zemabog due to family hardship. Arlen Mingliana, son of VL Muaka and Sons, resident of Kolosip, shall continue the construction of the building. We agreed that after the completion of the construction of the said building, he shall occupy the building for 30 years rent-free. We also agreed that he shall pay all the taxes incurred from the government during his occupancy in the building. Also, if any damages are found, he shall repair them. We agreed that after 30 years, the building shall be returned to me. However, if they wish to continue to reside in the said building, they shall pay the rent. Duration of the rent is 1991 to 2021. So this is the alleged agreement that was executed between S. Tansang and Arlel Mingliana. Now, Arlel Mingliana is my brother-in-law. Now, in the next page, after the duration of the rent is over, in the year 2022, in the month of December, a legal notice was received by me, and in which...
How many respondents are here?
Only one, my lord. The respondent is the daughter of S. Tansanga. Now, if I may take your lordship to page 50. 50A, I'm sorry, my lord. 50A.
58.
Yes. So
Yes.
now we know that the rent agreement, the alleged rent agreement, according to that, the period is over because the period was till the year of 2021. Now, in the year of 2022, in the month of December, I have received a legal notice wherein I was told to vacate the land within 30 days from receiving the notice.
Who are you? You happen to occupy that land?
Yes, that I'll come to that, my lord. Yes, in the fourth point, it is written that with my client's consent, even if the agreement does not include you as your husband, Mr. Novala is the brother of Arlel Mingliana. Now, my lord, my husband is the brother of Arlel Mingliana, who has executed the alleged rent agreement with Mr. S. Tansanga.
Where is Arlel Mingliana?
Arlel Mingliana, he
doesn't stay there.
No, he is working under police force in Meghalaya during that time.
Okay.
So
his brother stays there instead.
yes.
And you are the wife.
Yes, and we were all staying there in Zemabok during that since that time.
So legal notice was given to you to vacate.
Yes, because in that premises we have opened a shop by the name Muakataya. So it was not a residential building. However, we have that was our main source of income, that building. So in this point number 4, in the legal notice, it is written that as your husband, Mr. Novala, is the brother of Arlel Mingliana. However, Novala is my father, not my husband. So here there is also they did not verify the facts, which, and also, my lord, after receiving this legal notice, only after 2 months, Mr. S. Tansang has passed away. And that means that there is a chance that Mr. S. Tansang is not the one who have issued this legal notice, but this legal notice can be instigated by the respondent herself. So that is the case. And after this,
when did he pass away?
he, if I may take your lordship to page 47.
2 months after this legal notice.
Yes, 2 months. That is on 19th of
So,
February 2023.
It was before the legal notice. That means he must have done that.
Yeah, however, my lord, to only 2 months between that issuance of legal notice and the event of his demise, there's only 2 months gap. So the rent agreement was expired on 2021. So Mr. S. Tansang has the whole year of 2022. And then only at the end of 2022, that is on the month of December, he have issued this legal notice. And then after 2 months, he have expired. So there is a high chance that it is not S. Tansang who have issued this legal notice, but the respondent who have instigated in issuing this legal notice. Because the LSC number that is in the name of Mr. Lel Tansang is 37 of 1978. However, my LSC is LSC 332 of 2008. So there's a high chance that this legal notice is also instigated by the respondent. So there are certain facts that need to be adjudicated or tried through evidence stage in the trial court. So, and after this, eviction suit was filed by the respondent, wherein I have filed my written statement. And now going on to my facts of the case, in the year 1988, in the month of February, this Mr. S. Tansanga has approached my brother-in-law, Arlen Mingliana. He stated that I was in dire need of money. I could not longer construct a building that was already erected in his land. In 1988, only a structure of the building was erected, so he could not continue to construct his building. So, and then agreement was made between them. Arlen Mingliana bought the land of this S. Tansanga for a sale consideration of 150,000. So, and initially, only 80,000 was given by Arlen Mingliana to S. Tansanga, 80,000. And then since Arlen Mingliana is working in Meghalaya, he have to leave Mizoram. So he have told S. Tansanga, okay, since this is your old land, you will supervise and continue the construction. So for that construction, he gave 1 lakh. That means the total of money Arlen Mingliana gave to S. Tansanga is 1,80,000. So now that is February 1988. Now in the month of May 1988, Arlen Mingliana came back to Mizoram again to see how much construction is going on already. But that time, when Arlen Mingliana approached S. Tansanga, nothing was constructed. And then Mr. S. Tansanga had told Arlen Mingliana that I have spent all the money for personal use and only 20,000 is left with me. So he have give back that 20,000 left with him to Arlen Mingliana. That means all the money that S. Tansanga received from Arlen Mingliana is 1,60,000, whereas the sale consideration was at the beginning was 1,50,000. So another oral agreement was made between them that the sale consideration is completed. Now this is the facts of the case, my facts of the case, and after that sale consideration, that was in the month of May 1988. Now. Arlen Mingliana could no longer trust this Mr. S. Tansanga to construct his building. So now he have called upon his brother Arlen Mingtanga, who is my husband, my deceased husband, in the month of May itself. So I trust you are my brother. I trust you. Please continue construction of my building. Now. Arlen Mingtanga, who is my husband, started his construction in the month of May 1988. Now, he have finished the construction in the month of November 1988. During that time, only 2-story floors were constructed. So, And then in the next year, Arlen Mingliana had started a business by the name Muaka Tire. But however, this Arlen Mingliana, he is working in Meghalaya, so he is not able to supervise all his business. So he have kept his trust upon Arlen Mingtang, who is my husband, to run this business. So since then, we have run this business by the name of Muaka Tire. And then my brother-in-law, Arlen Mingliana, passed away in the year 1994. Since then, we have become the owner, and we have also occupied that building after the demise of my brother-in-law. So that is my facts of the case. And in my main ground is that in this, the spot verification was not exhibited. Even before trial has commenced, I was directed to vacate the land. So, being highly aggrieved and dissatisfied with this impugned order, I have filed this appeal. And if I may take your lordship to my grounds of appeal, that is at page 18 of my appeal petition.
No, before that, let
Yes,
us
my lord.
see the impugned. Where's the impugned judgment?
The impugned judgment is at
What?
page 27.
27.
Starts from page 27.
What is this page 60 review?
Yes.
Review filed by whom?
Filed by me, my lord. In this eviction suit, the plaintiff has annexed her heirship certificate in respect of this LSC 37, which was registered in the name of S. Tansanga. Now, we have filed a review petition during the pendency of this eviction suit. However,
For review of what?
heirship certificate, the heirship certificate. My lord, if I may take your lordship to page 47, that is the heirship certificate annexed by the plaintiff in her eviction, in the plaint of our eviction suit.
You have filed review on what basis?
Against this heirship certificate. However,
On what basis?
because we already have an LSC in this land. So, but however, the review court was of the view that I do not have the right to file the review, so I have prayed for withdrawal in the
see.
review petition, yes.
Now, they have filed eviction suit.
Yes,
The plaintiff is the daughter of S. Tansanga.
yes,
Correct.
my lord. Yes, my lord.
So she filed eviction suit
Yes,
to evict you from that land.
yes, my lord.
And the court has ordered for a
For,
verification.
yes, conduct of spot verification.
By which order?
My lord, I do not have the order with me today.
The LSC, the TCR is here. This is order dated 25/4,
24, yes, my lord.
25/4/2024.
Yes, my lord. Then spot verification dated 22nd 5 of 2024 was submitted before the court on 7/6/2024, according to the impugned judgment and order.
Impugned judgment is what, 25/7?
Yes, 25/7.
Today's fixed for spot verification. Today's fix for spot verification. What is this? Spot verification input. And the same is, have you seen the spot verification?
No, no, my
You
lord.
should have checked the orders. You should have checked the TCR. Where's the spot verification? Oh, this is the verification report. 2nd June. I think
Yes, my lord.
briefly what the survey report has said that the LSC of 2008 was issued earlier.
Yes,
So that's why that should prevail.
yes.
So basically that's what it says. And of course there's some reasons given here, but thing is that after the verification report was submitted,
Yes, my lord.
then a copy of this should have been given to
Yes,
both
my lord.
parties.
However, on the next court date, we have received the impugned judgment in order, in which the
So I think it
report
should
was
go back.
reflected.
This court will not decide who is right or who is not.
Yes, my lord.
Since you have initiated that, what do you call, eviction suit, and rightly or wrongly or whatever the court thought that we should go for a spot verification. Verification was done, but parties were not given any chance to
Yes, my lord.
make their submission or go through this, and decision came.
Yes, my lord.
On this note, I think it needs to be sent back. What do you say, Mr. Counsel?
Yes, Lordship, with regard to that, may I take your Lordship to page number 32 of the appeal petition?
32?
Yes,
Yes.
32 second para, Lordship.
Yes.
May I read, Lordship?
Yes, yes.
On dated 25/4/2024, this court conducted preliminary hearing and on careful perusal of the LSC submitted Land Council for both parties pray to conduct spot verification in order to ascertain the exact location of the plaintiff LSC as well as LSC of the defendant, and to find out as to whether LSC of the plaintiff and the defendant are encroached to each other. Hence, Director Land Revenue and Settlement Department, Government of Mizoram is requested to make suitable arrangement for spot verification. In pursuance of this court request, Director Land Revenue and Settlement Department, Government of Mizoram detail KLR Chanpuya, surveyor and the said surveyor conducts spot verification in the presence of both parties along with their land council and member of local council Zemobok, and submitted spot verification report before this court on 7/6/2024. So, Lordship, based on this, I'm just reading. It appears that that spot verification was conducted on the basis of both parties' prayer, and during verification was conducted, both parties as well as council were also present beside the local council. So, Lordship, and yes, during the proceedings before the trial court, they did not make any objection with regard to the same. Besides, during verification was conducted, as I have already mentioned, they were present, they saw the result, but any objection was not raised by the appellant during the proceedings before the court. Besides, Lordship, is Order 26, Rule 10, Sub Rule 2 of CPC clearly stated that the report of the commissioner is also a part of the record. So, Lordship, here in the instant case, as I have already mentioned, both parties made prayer for spot verification, and on their payer that verification was conducted. Both parties were present. Counsel were also present. They saw the result, but no objection was raised by.
No, how do you say they saw the result?
Yes.
Because Lordship,
We cannot influence what is written in the
during spot verification was conducted, all the parties as well as the counsel were present, Lordship.
No, I understand, parties are there, they
Yes.
were there. But I'll tell you, the result was perhaps not known. It cannot be known because spot verification happened on 22nd of May,
Yes,
2024.
yes,
And the surveyor prepared his report on 24th of May,
yes.
2 days after that. So after preparing the report, did he give a copy to every one of you that this is my report? So that is the part
No,
which
my
we are looking to.
Yes.
We are not saying that report is correct or report is wrong.
Yes.
Only thing is that the party should have a sufficient chance to inspect and, like rebut the report or to adopt the report, whichever it may be.
Yes.
So that aspect is missing because court said that, okay, I have seen the report. Let me hear the parties now. You hear the party and the judgment passed.
Lordship, actually, trial court also fully relied on the spot verification because when
That is why, if he relies upon something, that reliance placed has to be, party has to be given a chance to rebut that. That aspect is not there. Merely saying that I'm here, the parties will not do. Chance has to be given, means meaningful chance has to be given.
Yes, my lord.
This is only what we are at.
And beside Lordship, beside that spot verification report, actually the appellant has no merit in the present case at all. Because if I may take your Lordship to page number 53 of the appeal petition, 53 second para. May I read, Lordship?
Yes.
The plaintiff father, namely Tansanga, during his lifetime had a landed property located at Jemabok, Aizawl, Mizoram. During the lifetime of the state Tansanga, sometime in the month of February 1988, he approached Sri Lalming Lianabai saying that he wanted to sell his landed property since he was in dire need of money. It is pertinent to mention here that at this point of time, there was only a structure of building within the said landed property. At last, with due consideration, Sri Lalminglian agreed to buy the landed property with a sum of rupees 1,50,000. I will read up to that, Lordship. From this, this is the written statement submitted by the appellant before the trial court. And from this, they are saying that they have bought my father LSC at a rate of rupees 1,50,000. But there is no such sale deed or any document showing that they had truly bought the said LSC. And beside, Lordship, if I may take again you into page number 56 of the appeal petition. Yes. I will not read out again, but in the first para, it is very clear. They are saying again that Arlal Mingliana, which is the appellant husband brother, they are saying that Arlal Mingliana had gave that landed property to his brother Lal Ming Thanga, which is now the appellant husband. However, here also, Lordship, there is no such gift deed or any document showing that Mr. Lal Minglian had truly give the landed property. And yes, Lordship, beside that, by presuming, however, not admitting the fact that if Mr. Lal Minglian had truly bought my father LSC, then how my father name as well as my grandfather is different, can come different in the LSC, because if I may take you again, your Lordship, into page number 43 of the appeal petition. 43. Yes, that is my father LSC. There we can see that my father name is S. Tansanga and my grandfather name is L. Tingura. And below that, inside the box area in Biga, my father property is also 199.16 square meter. And if we come again to page number 63, Lordship, 63 of the appeal petition. Yes, there we can see that my father name is Tansanga, not S. Tansanga, and my father name is Namduna. Well, my grandfather name is Namduna. Well, my correct grandfather name is El Tingura. The name is completely different, Lordship.
Okay.
Yes, from these two LSC also, it is very clear that the appellant had fabricated LSC, and below that, below the name, there is a box. Inside the box area in Bigha also, Lordship, the square meter is also different. And as I have already mentioned, my father as well as grandfather name are also completely different, Lordship. So they are not objecting that the initial owner is my father, and they are saying that we have bought my father LSC. But Lordship, if presuming, however, not admitted that if they truly bought my father LSC, how can my father as well as my grandfather name can come different? So Lordship, if the matter was also remanded back, actually they have no merit at all, Lordship. That is the thing.
So these will be examined by the trial court.
Yes, exactly, my lord.
What is the explanation for this?
Because these are two different LSC, my lord. And according to my learned friend, it appears that my LSC is not in the land of his fathers. That means there is a title issue also in there, and also the LSC needs to be properly located. So I think this matter is to be
This
remanded.
page 43.
Yes. Yes, my lord.
Page 43 is annexed to what? Annexed to the eviction?
Eviction suit, yes, my lord.
And the other one?
And then 63 is annexed to my written statement.
Written statement or review?
Written statement, my lord. Annexure 2 of my written statement.
I see. Why have you brought this LSC?
That is the LSC that we have owned, and I believe that in which my building is situated.
Okay, so we'll send it back. Let this issue also be taken into consideration by the court.
Yes, my lord.
Hard Miss.
H. Lerosang.
Lordship, please may I
And-
interrupt you?
Huh?
May I interrupt you with sincere apology? If it is to be sent back, could the disputed property please put under lock and key, or at least maintain status quo until and unless disposed before the trial court?
What is the situation as on today?
As of today, it is under lock and
Yes,
key.
and lock and key, and beside this honorable court also put the trial court order in that eviction as well as execution case. This honorable court had already put under status quo. So Lordship, if status quo is further maintained, it would be most fair for both
My
the
lord,
parties.
in that,
Because actually, we are saying that we are the real owner.
however, my lord, I have been in peaceful possession for more than 30 years. And only just after the death of this Mr. S. Tansanga, the respondent had belatedly filed a suit against me. And also this eviction suit ought to have been dismissed at the threshold because there is a dispute in the title. So this eviction suit itself is also not maintainable because the nature of the case and the issue is not a matter of eviction, but a title suit or by way of civil suit.
No, you challenge that. You challenge that before the trial court.
Yes.
What is this stay?
Stay application.
There was a stay. There was a stay.
Yes, my lord. In that case, my property was not kept under lock and key at the time of filing this stay application. So today I did not press on this application much and pray for disposal of the main appeal.
Status quo as on today shall be maintained with regard to the order dated. That was the order. Status
Yes,
quo.
Yes. And status quo was the building kept under lock and key.
Who has directed the building to be kept under lock and key?
The executing court.
Executing
Yes.
court. Okay. Executing court is the same court?
Yes, my lord. So now it is kept in abeyance, the execution proceedings. During the pendency of this appeal, it is kept in abeyance.
All right, please write. Heard Ms. H. Lal Rosangi, learned counsel for the appellant, and Mr.
K. Kham Thian Manga.
K.
Kham Thian Manga.
Kham Thian Manga,
Yes.
learned counsel for the sole respondent.
Yes.
Stop. This is an appeal filed by the appellant. Against the order dated 25/7/2024, passed by the learned civil judge, senior division, Roman 2, Aizol, in eviction suit number 3 of 2023. By which the learned trial court has directed the appellant to vacate the suit land covered by LSC number 37 of 1978 within a period of 3 months from the date of the order. There's another execution also.
Yes, my lord.
Where is that? Have you annexed it?
No, my lord. At the time of filing this appeal, execution petition was not filed yet by the respondent.
Then execution came at what stage? After the appeal?
Yes, after the appeal.
Any order was passed?
After this appeal was first condemnation, I
No,
have
Lordship.
filed a condemnation application, and after consideration of that condemnation application, the respondent has filed an execution petition.
That execution was filed in November 2024, and this appeal was filed on 12th December 2024, Lordship. After filing of the execution, they only filed.
Yes, what is the order passed in the execution?
It has directed the property to be kept under lock and key.
Where is the order? We don't have the order, so
I
why
don't
should
have
we
the
bother?
order with me. I don't have the order with me, my lord.
It is not on record anywhere.
Not in this appeal, yes.
Then we need not refer it. What is the requirement? Stop. The learned counsel for the appellant submitted that during the pendency of the submits that after the eviction suit was filed, the notice was issued to the opposite party / defendant fixing 30/5/2023 as the date for submission of written statement Was it filed written statement?
Yes, my lord.
When?
It, it was filed in February 2024. Before filing of the written statement, my lord, a review petition was filed arising out of the heirship application obtained by the respondent.
Then, right, after several dates, the written statement was filed by the defendant on 13/2/2024. And a date was fixed for preliminary hearing. Stop. Accordingly, a preliminary hearing was conducted on 25/4/2024, on which date the court, upon hearing the parties, found it to be a fit case for conducting spot verification by the Land Revenue and Settlement Department. Stop. Accordingly, a direction for making a verification was issued to the Director of Land Revenue and Settlement Department, Government of Mizoram, asking the state authority to make suitable arrangement for spot verification to ascertain the exact location of the plaintiff's LSC as well as the LSC of the defendant, and to find out as to whether the LSCs of the plaintiff and the defendant are encroached to each other or not, and to submit spot verification report on or before the next court date. So accordingly, 14/6/2024 was fixed as the date for submission of spot verification report. Stop. On the fixed date, the court, after receiving the spot verification report, fixed 25/7/2024 for hearing the parties. And accordingly, on that day, the suit was allowed in favor of the plaintiff / respondent. Which is now put to challenge through the instant appeal. Next para, the learned counsel for the appellant submits that. You want me to reflect the review also? Review.
No, my lord, it's fine.
Submits that The learned trial court did not give any opportunity to the appellant to examine the verification report and thereafter to rebut the same, if so necessary, by examining the surveyor who conducted the spot verification. Stop. Instead, the learned trial court, solely on the basis of the verification report, proceeded to decide the matter in favor of the plaintiff respondent. Stop. The learned counsel therefore submits that the impugned order of eviction dated 25/7/2024 passed by the learned trial court should be set aside. Next para, per contract, Mr. K.
Kham Thian Manga.
Kham Thian Manga.
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 Yes.
K. Kham Thian Manga. It is here, okay? It is available here. Learned counsel for the sole respondent submits that the appellant agreed to the spot verification and was also present on the spot on the date when verification was done. Stop. The appellant therefore took part in the verification process and was fully aware about the result of the verification. And therefore, the stand taken and therefore the ground taken that the appellant was not given due opportunity to examine the verification report is not tenable. He submits that the suit land belongs to his father, Mr. S. Thansanga, who had started some construction on the suit land but could not complete the same. Stop. He therefore permitted the appellant, respondent, to make the construction and occupy the land for 30 years. Stop. Since that 30 years has lapsed, the appellant, respondent, who is now occupying the suit land, was requested to vacate the suit land, but as she did not agreed to the same, the eviction suit was filed. Stop. The learned counsel also submits that, as per the certificate of land settlement annexed to the eviction suit, the same is issued to the plaintiff respondent's father, S. Thansanga, and his father's name and her father's name is shown as L.T. Moora of Zemabog, page 43, okay? Stop. Whereas in the written statement filed by the appellant stroke defendant, the land settlement certificate is issued in the name of Thansanga, and father's name is also shown as, and the father's where the father's name of Thansanga is shown as Namduna, Namduna. Full stop. There is also no similarity. You record that, page 63, okay? That spelling, page 63. There is also no similarity in respect of the area of the land. That is 245.23 square meters has been shown, which differs from the LSC issued in favor of the plaintiff's father, for an area of 199.16 square meters, which is annexed to the eviction suit. The learned counsel therefore submits that under the facts and circumstance, the appellant cannot have any claim against the cannot have any claim on the land of the respondent plaintiff, which she has inherited from her father by way of a heirship certificate.
Heirship certificate plus rent agreement, Lordship. Rent agreement.
Rent agreement.
Yes.
Rent agreement, but that is not yet proved.
By way of
The
that
the
heirship
genuineness
certificate.
of that alleged rent agreement is not yet proved.
Heirship certificate, okay. Next para, I have heard the submissions made by the learned counsels for the rival parties, and I have perused the materials available on record. Stop. What has been noticed by this court is that after the respondent plaintiff, no, after the appellant had submitted her written statement against the eviction suit, a preliminary hearing was conducted by the learned trial court on 25/4/2024, wherein the learned trial court found it expedient to direct the conduct of a verification by the revenue authorities. So it was accordingly ordered, and following the submission of the verification report, the matter was fixed for hearing, and on the date fixed, the eviction suit was disposed of in favor of the respondent plaintiff. Stop. The materials on record does not indicate that the parties concerned were given a copy of the verification report and thereafter given an opportunity to rebut the same. Stop. Although the learned counsel for the respondent submits that the parties had appeared on the day when verification was done and that the appellant was aware about the result, but the fact remains that verification was done on 22/5/2024, and the verification report was thereafter prepared and submitted on 24/5/2024 by the detailed surveyor. So therefore, this court is of the view that the parties ought to have been given the opportunity to either rebut or otherwise the findings given in the verification report before a conclusion can be reached by the trial court.
Lordship, may I? Verification report was submitted on 7/6/2024.
From where are you saying that?
Page number 33, appeal petition, first para.
33.
First para.
This was submitted before the court. I'm talking about the verification submitted by the surveyor
Yes.
before the director. The learned counsel for the respondent has drawn the attention of this court where is this from? Page 33.
The impugned judgment and order, my lord.
To the impugned judgment, to the impugned order dated 25/7/2024, passed by the learned trial court, wherein the court has recorded that verification report was submitted before the court on 7/6/2024. However, a perusal of the order sheet of the learned trial court goes to show that the spot verification report was received by the court on 14/6/2024. And thereafter, a date was fixed for hearing, that is 25/7/2024. So be that as it may, this court is not on the date on which the verification report was submitted, but on the issue, but on the fact that the verification report, but concerned with the fact that the parties concerned have not been given due opportunity to rebut or otherwise the verification report as projected by the appellant. Stop. Moreover, the records also do not reveal that such opportunity was granted, except that a hearing date was fixed. Next para, another aspect of the matter which has drawn the attention of this court is with regard to the variation as regards the land settlement certificate presented by the plaintiff respondent and the appellant defendant. Stop. As already stated herein above, there is no similarity in the registration number of the land settlement certificate, comma, the father of the registered LSC owner, and also the area of the LSC, and also the area of the land. Stop. All that appears to be similar is with regard to the name of the registered owner, that is Thansanga. Which, however, is again registered as S. Thansanga in respect of the LSC produced by the plaintiff respondent. So, this aspect of the matter also requires appropriate examination by the learned trial court. By giving due opportunity to the parties concerned. Next, under the facts and circumstances, this court is of the considered view that it is a fit case for remanding the matter back to the learned trial court for consideration, for fresh consideration in accordance with law. Stop. In other words, it is provided herein that the survey report, which is sought to be relied upon, it is, what did I say in the last line? It is, in other words, it is provided herein that the parties to the suit should be given due effective, should be given proper and effective opportunity for should be given an opportunity, should be given the opportunity to rely or rebut upon the spot verification report submitted by the surveyor concerned, apart from any other materials which they wish to rely upon. The learned trial court shall also take note of the fact that not take note, should also consider and take a decision as regards the differences found in the two LSCs projected by the presented by the rival parties in accordance with law. Anything else?
And
Lordship,
my lord, there is still IA, that is stay application.
That will go.
Yes, and my lord, I need to apologize for my wrong submission. In the stay application, I have annexed the execution, order of the execution petition, which has directed the building to be kept under lock and key. However, if this eviction suit is remanded back, then this execution petition has become infructuous. So,
You have only sought for stay of the execution. You have not sought for setting aside of the order of eviction,
yes, my lord.
the order passing the eviction suit.
Yes, Lordship, may I?
Hmm.
Yes, as my learned friend had mentioned that the disputed property is under lock and key, and beside, with regard to that eviction suit as well as execution, this honorable court on 28/3/2025 had maintained status quo upon the true order, so Lordship.
In which case?
In regard to this case.
I know, in the IA or in the RFA? That order was passed in what?
In the IA, Lordship, IA 48/25. With regard to their stay application.
Next para, before parting with the records, it is also noticed that this court in IAC number 48 of 2025, arising out of the instant RFA, had directed the parties to maintain status quo. Invite order dated 28, did I say that date already? Invite order dated 28/3/2025. To stop. Court is informed that the parties are maintaining status quo as on today. Stop. Considering the same, the parties shall are directed to maintain status quo. Till the final disposal of the case.
Yes.
Stop.
If I may be allowed to make one more submission, Your Lordship. Actually, this building is kept under lock and key only because this execution petition has been filed. So now that the eviction suit is remanded back to the trial court, this execution petition has become infructuous. So if I may be allowed to open my building, because it is my main source of income, and I have been refrained from running my business for so long.
Your Lordship
And
has
there is
yes, power to
financial
state that
hardship cost
status quo.
due to
because
the eviction suit filed by my learned
if-
friend.
If it is kept under status quo, it would be most
Because
fair
title
for the
is not,
parties.
title of the property is not
Please,
yet proved.
please read the last line. Before that, before parting with the records. Considering the same, you cancel that, okay? Before that, before parting with the records, from there also you cancel. Don't not write that. What was the last line? Yes. Okay, now you write. In the result, the Impugn order dated, what is the date? So and so.
30th.
Impugn order dated
Oh,
25,
sorry, 25 July.
25/7/2024 is hereby set aside. Passed in
Eviction suit.
eviction suit number 3 of 2023 is hereby set aside. Stop. Since both the parties are represented before this court, they are directed to appear before the learned trial court on, when will you appear?
Lordship, if possible, 2nd April.
Which court is this? Before the learned trial court? Is it the same court?
Yes, senior civils, that's one.
Before the learned trial court, within bracket, no, that is seniors, that is Court of Civil Judge, Senior Division, Roman 2, Aizawl District, Aizawl. On, when did you say?
2nd April, Lordship, if possible.
Is it okay with you? 2nd April?
Yes, my lord.
2nd April 2026. Until such time, the status quo order passed by this court on (28/3/2025) in ISC number 48 of 2025, arising of the instant appeal shall be maintained. Stop. On appearance of the parties, the court shall proceed in accordance with law as observed and directed herein above, and make an endeavor to consider and dispose of the case as expeditious as possible. Stop. The parties also will be at liberty to pray for extension of the status quo order or otherwise by filing appropriate application. Stop. In the event of filing of such application, the learned trial court shall consider the same in accordance with law and pass appropriate orders. And leaving it to the trial court, the TCR be sent back to the sent back forthwith.
Obliged, my lord.
Then both the IAs are disposed, okay? How many IAs are there? One. In view of the order passed in the main appeal, IA also stands disposed.
Hearing list, item 2.
Just a minute. There's nobody here, so no need to give it. I know there's nobody here. Who's there for the appellant? This Rupesh Datta, he's an outstation lawyer.
Yes, Your Lordship. Even in the last court date, they appeared through VC.
Is he appearing through VC today?
I have no idea, Your Lordship.
Court Master, if people prefer to appear on by VC, they have to take permission. Not that they just appear suddenly like that. At least the court should be informed that so and so wants to appear by VC, so that we know. Otherwise, we will not wait. See, there's nobody there, so why should we wait? No one appears for the appellant when the matter is called. Ms. Barnesiami, none additional PP is present for the state. This is the matter again after 2 weeks.
Lordship, regarding item number 10 of hearing list,
Part through item number 10. Part through item number 10, my lord.
Yes. What about that?
My lord, as there is a settlement in the outside court, so I would like to withdraw the appeal.
Huh? What are you saying?
RFA, it's appeal against the judgment in order passed by the Civil Judge Senior Division Colosseum.
So?
So I'd like to withdraw the case as per the
Lordship,
agreement.
there is an amicable settlement outside the court between the parties.
Where's the settlement? Give it to me. Is it signed by both the parties?
Yes, my lord.
So your submission should be that there's an amicable settlement between the parties, and we would like to matter to be disposed accordingly in terms of that. What is the issue here?
The issue is as the Civil Judge Senior Division has passed an order by making that
What is the bone of contention? Just tell me in 2 words.
the
Property.
Yes, my lord.
Dispute on a property.
Yes, my lord.
Okay. Now, how is the settlement done?
It should be both the
Apportioned.
parties between, yes, 50-50.
Apportioned.
Yes, my lord.
The appellant and the respondents they are related to each
Yes,
other.
my lord. Family.
Family.
Yes.
And this agreement has come, the settlement has come when? When was it signed?
It was signed on 7th February.
7 February.
Yes, my lord.
Where is the date?
It's on the, if I may take you to the Mizo version of page number 2, the last para.
Okay, 7 February, okay. Please write hard, Mr.
Zodin Penamte.
Zodin Puyanamte, learned counsel for the appellant, and Mr. Lalla Maralte, learned counsel for the
Respondents, all the respondents, ma'am.
for all the respondents. So at the outset, the learned counsels for the rival parties submit that the parties have come to an amicable settlement by signing an agreement on 7/2/2026. In front of 2 reliable witnesses. Stop. They submit that the sum and substance of the agreement is that the parties have agreed to divide the suit property amongst themselves in the manner indicated in the agreement. Stop. In support of their submission, the learned counsels have produced a copy of the agreement, a copy of the original agreement in Mizo vernacular, along with a translated copy of the same. Stop. The translated copy of the agreement is being abstracted here under. You have to abstract this, okay? The English one. The learned counsels for the parties, next para, thus submits that the instant appeal may be disposed of in terms of the agreement reached between the parties. Stop. Upon considering the submission made and perusal of the agreement said to have been signed by the parties, the appeal is disposed of in terms of the agreement dated 7/2/2026. We'll retain a copy of the agreement here. Or you require?
It's okay, it can be in the.
Do you have a copy of this
Yes, my lord.
agreement? How many copies have you made?
Yes, of now, only one left.
Only one?
Yes, my lord.
The vernacular one? Only one?
Yes, my lord.
You have one? You don't have?
I
My
already
lord,
said-
we have our own copy.
And you also have your own copy?
Yes, my lord.
So we can retain this.
Yes.
The agreement produced by the learned counsels for the rebel parties is retained in the record. And is marked as X for identification. So this was item number
10 of
10.
part two.
Tomorrow is Wednesday, right? And
Yes, my lord.
any matter fixed for tomorrow? All right.
Right, my lord.
Much obliged.